Good evening. Before we start, I always say more or less the same thing, but occasionally people who are here have not been here before. So I'll be very brief by simply saying I would remind you that we are the Planning Commission, not the Town Council. We do not have the powers of the Town Council by and large. We simply follow their lead and first the law. Secondly, each person who wishes to speak will be given an opportunity to do that, and that's divided into two parts. One is the general comments, and that is you can talk on a matter not before us to which we cannot respond, but you can talk. That's a public forum. Secondly, if you're an applicant or wish to speak on a matter, you can speak to us on that. The applicant gets 5 minutes. Others get 3 minutes. The applicant gets a rebuttal of up to 3 minutes. There are cards in front of some of you, and you fill those out, and if you please give them to the clerk so we'll be able to call on you in the order they come in. I'd appreciate that. Then I think the final thing I would say is if you have something that makes noise when it gets a telephone call or something like that, I'd ask you to silence it or turn it off. That having been said, I'd ask for the roll call.
Thank you, Mr. Chair. Commissioner Erickson?
Here.
Commissioner Jensen?
Here.
Commissioner Sayoc?
Here.
Commissioner Machici will be late, but he will be here this evening. Commissioner Talasfor?
Here.
Vice Chair Bourgeois?
Here.
And Chair O'Donnell.
Here.
Thank you. We have a quorum.
Let me say that we expect Commissioner Machici in roughly 10 minutes. I'm hopeful that we will not have gotten into the testimony of a public hearing before he gets here. If he does get here after we've begun testimony, he will not participate in that matter. So I say that, and we can all keep our fingers crossed on that one. All right, so if we could do the Pledge of Allegiance, I'd ask Charles Erickson to lead us in that. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Next matter we'll consider would be the approval of the minutes of May 27th. Do I have a motion? Commissioner Talasfor?
Yeah, I make the motion to approve minutes of Wednesday, May 27th.
Is there a second? All right. Commissioner Sayoc. Is there any discussion? Commissioner Erickson.
I'll be abstaining since I was not in attendance at the meeting.
All right. All those in favor? Aye.
Aye.
So we have one abstention and one commissioner excused. The next matter would be, do we have any written communications?
You have one desk item tonight.
Okay.
And that will be on 930 University, and other than that, everything's been included in your packet.
Thank you. We have one requested continuance, and that's item number 1, which is 15928 Union Avenue. Is there any question about that? Commissioner Erickson?
I would move to continue subdivision application M0813 and architectural site application S0830 to the meeting of the Planning Commission on August 12th, 2009, since the environmental review for the project has not yet been completed.
Is there a second?
Second.
Commissioner Bourgeois. All those in favor?
Aye.
So I guess if I count, that's 6 in favor and 1 commissioner excused. On subcommittee reports, we had one subcommittee meet this evening that I'm aware of, so I'll ask for reports of that committee and any others. Commissioner Bourgeois.
Thank you, Chair. The General Plan Committee met prior to this meeting this evening to discuss the affordable housing strategy. We had received a memo on the town's strategy. We had provided comments, and we were just examining the revisions to make sure that the report met our satisfaction before it will be forwarded to Council for final action.
Any other committee reports? Commissioner Erickson.
The Historic Preservation Committee has met twice since the last one, once on June 4th and another time on June 14th. Took action on 5 items at the June 4th meeting and 2 items at the 14th. In the interest of the potential length of the meeting tonight, I think the members of the commission have received minutes from that meeting, so I'd be happy to answer questions of commissioners offline if they have questions about the actions of the historical preservation on the particular items at those two meetings.
All right, are there any questions of Commissioner Erickson on those meetings? Thank you very much. Now I think we can move to verbal communications. The first card I have is Citizen Ray. I've often wondered that, Ray. Well, this time you're not.
Oh, good. Yes. As you know, I've reported to you that I've been here in Los Gatos for 10 years looking for a homeowner association. I still can't believe it. 30,500 people, and there isn't one single homeowner association. It is unbelievable to me. So the advocacy of the public interest falls on the shoulders of one guy. Who's that? Me. One guy for 30,500. So I hope you appreciate that. Point two. You're under pressure continually for a property tax gain for the town of Los Gatos so that the public budget can be maintained. Okay? And we have the Wasserman, the mayor, who continually minimizes the amount of money involved in property taxes to the town of Los Gatos. And I want to tell you, beyond any shadow of a doubt, that this past year there was $8 million in property taxes, okay? And that's just $1 million shy of the retail sales. So property tax is a huge goal from the Gang of Five that run this town, okay? And you are always under pressure to lay down your standards and approve everything that comes before you for the dollar bill. Period. End of story. So hooray for you people who have enough personal integrity to see through the nonsense that the Gang of Five promotes. And I thank you for one. The last item, and this is an introductory presentation. As you know, I go to City of Saratoga, City of Montesreno, City of Orinda. I go to various nearby communities, okay? Orinda, not one. But what I'm finding out now, that we have Los Gatos and all the South Bay communities close by have a tremendous problem in air pollution. And you might think it's automobiles, but it isn't. The automobile situation is working its way out. It's unbelievable. No more dirty blanket as you come from the ocean, okay? You see the mountains, the air is fresh. And I'll wind it up. There is a cement plant in the hills of Cupertino that puts out over 1 million tons of obnoxious gases annually. And we are breathing it. And the communities involved are getting together now to get some equity for the you, I, and everybody else that breathes that public air. Thank you.
Thank you, Ray. Tony Jeans.
Tony Jeans, 170 Stacia Street, Los Gatos. I really just wanted to talk a little bit about what I see in the staff and recent things that have changed. I want to welcome Wendy. I think she's already doing a very good job. I think we as the staff, we as people who come to talk to the town of Los Gatos are talking to probably one of the more knowledgeable staffs that I've had to deal with. When we're doing development projects and taking them to towns and cities throughout the area, Saratoga, Montessorino, Los Altos, etc., which I do quite often, I think the group of people that you have here, both at the planning level, the building level, public works, engineering, throughout, you've got a really exceptional group. And I'm hoping that you can keep that group together. I know that there have been some losses over the years, and I see the turnover being reasonably low, and I hope you can keep it that way, because when they're out trying to respond to issues that are out in the field, whether they're building issues or public works or engineering issues, they're prompt, they come out, they're courteous, they deal very well with the public, they have a large number of complaints that they have to deal with, they have to deal with neighbors, they have to deal with people who don't always like development that is going on, and I think that they do an incredibly good job from all aspects of the staff level. And I think that we owe really a round of applause to the staff and the way that you've put them in place, from the higher level down, from the director level, all the way down through the junior people at staff who become productive very, very quickly because they have great people to learn from, such as Sandy Bailey, such as Joel in the planning side, and even the recent turnovers that have happened in engineering and public works, the loss of Fletch and people like that, people such as Trang and John Gaylord have stepped up, and they've jumped right in, and you've got a very good department. And I hope that all the negativity that often comes out at meetings such as this, that's heaped on them by some people, I want you to know that there's really a lot of very positive feedback that comes to me, and I'm trying to pass that on to you in acknowledging the people that you have here. You've got a good team.
Thank you very much. It's always a pleasure to listen to compliments to staff, so thank you very much. From whomever. The next item we have is really the second item on the agenda, 15,500 Francis Oaks Way. Commissioner Bourgeois.
For the record, I want to state that I'll be recusing myself from this item. Someone at my company was involved in one of the environmental issues on this topic tonight, so I will be stepping out.
Thank you, Commissioner. All right. Again, unless Commissioner Machici gets here before we begin testimony, he will not participate, so we'll see if he does. All right, so the first thing I would like to have is a staff report.
Good evening. The property is located on the south side of Francis Oaks Way at the upper terminus of the road. This is an 8-acre site, and it drops all the way down to a low point that is accessible from the Highlands of Los Gatos development. The Highlands plan development does border the property on two sides. The property is zoned HR 2.5. There's an existing residence on the property that was approved by the town in 2000. And in addition to being bounded on the south and west by Highlands, the other sides have existing hillside homes developed on them along Francis Oaks and over on Green Ridge Terrace. There was a previous proposal to subdivide this property that came before the Planning Commission in 2006. That application was denied by Planning Commission and went to Council on Appeal, and the Council remanded it back to the Planning Commission when they considered it in March 2007 based on new information. The resolution from that action was attached to your staff report. The proposal remains a subdivision for 2 lots. The original building site was up at the top part of the property. closer to the existing residence and was going to be accessed from Francis Oaks Way. This submission has the building site shifted to the lower portion of the property and is proposing to access through a private easement from Shady Lane. So the development would be coming in from Shady Lane through the Highlands project and then through an easement to get to this building site. Parcel 1 is about parcel 1 is about 4.8 acres. That is the upper lot, and the existing residence would remain there. Parcel 2, the lower lot, is about 3 acres. The existing residence is staying. Nothing's changing with that particular property in any way at this point. The applicant has offered to grant a scenic easement, and this was something I did not mention in the staff report, but it is shown on the tentative map. The highest point of the property, which is the most visible, is where they've placed the easement, and the easement would just preserve that area in a natural state and allow only native plantings. So if the subdivision is approved, I would suggest adding a condition requiring the easement to be granted, and I do have suggested language. If you'd like that, I can read that later. We did redo the geotechnical evaluation for the property and did a site-specific for the new building site that's being proposed, and that was cleared by our consultant as being geotechnically feasible. We also took the mitigated negative declaration that was done for the project and updated that for the new project, and that was sent out previously, but it was also attached to your report. The public period for review on that ended on April 28th. We did receive comments from one person, and that was attached to the report, as was a response from our environmental consultant. There are 7 findings specified by the Subdivision Map Act, and these are sort of reverse findings. If you can make any of these findings, it is grounds for denial of the project, as opposed to making findings for approval. Should the Commission wish to approve the project, you need to make the negative declaration. There is a mitigation monitoring plan that needs to be adopted along with that. And we also have attached conditions of approval. And the only change recommended to the conditions would be adding one for scenic easement. Final action must be taken this evening. The staff report indicates that the final action date was June 21st. The applicant did agree to waive that to allow the application to be shifted to this meeting, and that was because the previous meeting was canceled and they weren't able to be on that agenda. So we do need to have a final action on the project this evening. And staff is available if you have any questions.
Commissioners, do any of you have questions? Commissioner Jensen?
I think this is actually a question for Mr. Korb. Our staff report contained information regarding the Highlands development, Mr. Harris's dispute regarding the nature of the easement and whether or not it can be used for access to this property, and also attached correspondence from Mr. Harris's lawyer. And I'm wondering if there is any litigation that has been filed or is now pending.
Can I just add, now that Mr. Machichi has arrived at the House, can I ask you just to repeat your question one more time so he can hear it and then know my answer? I'm sorry.
I'll try.
Ask you to do that.
We received information in our staff report regarding a dispute over the easement that is proposed to be used for access to the property. We also had correspondence attached from you and Mr. Harris's attorney regarding that easement, and I'm wondering, is there any litigation that either has been filed or which you expect to be filed or is now pending?
There is no litigation that I'm aware of. We have not received notice of any litigation. Of course, if any litigation were initiated, we would honor whatever the ruling of the court may be with regard to the easement rights, and if any injunction issued, of course, we would honor any injunction that might issue. But to date, I'm not aware of any litigation.
Want a follow-up question?
Follow-up question. There is also an indication in our staff report that part of the property may involve or touch upon the Ross Creek area, and I'm wondering if the pending dispute regarding that area should be considered with this property.
We have no basis for making that connection. It's well downstream.
Thank you.
Was there another question? Commissioner, yes. Alice Ford?
Yeah, I have a question of staff, and that is in the staff report, page 5, at the top of the page, Town code does not prohibit access by private easement. However, it is not as desirable to create a lot that will be landlocked should access rights be lost or severed. as it is to have a direct access from a public or private street. So my question is, how could the access be severed, and what would it happen if it were to be?
If there were, the access could be, if the project were approved in its present form and Mr. Harris chose to litigate, the applicant could potentially lose that suit, and then they have no access. So there is that possibility, but that's just speculation at this point.
Okay, so
They would not be able to develop the property at that point if that occurred.
Okay, that's sort of what I needed to know. There would be no building of.
Correct.
Thank you. Okay.
Yes, Commissioner
Just to
Jensen.
put the cart before the horse a little bit, I have a real question about how we can consider the property, which so much part of it is a question regarding the access. And in 2006, that was an issue. How could we consider making the proper findings if we have no idea where the access is actually going to come from?
Staff has, as part of the application, required that the applicant present proof of access. The applicant presented the easement agreement with the neighboring property owner. The easement agreement, as I reviewed it, indicated that the access was existed, that it was not restricted, and that it was sufficient for purposes of the subdivision application. Now, the neighbor, the grantor of that easement, says that the intent of the agreement was to the contrary. That's not apparent on the face of the agreement. They can raise that issue if they wish. Your choice today is to act on the application before you. You can approve the application based on the understanding that the easement agreement is sufficient, and with the understanding that well down the line, perhaps, or sometime in the future, that access may be challenged by the grantor, and if so, then the subdivision effectively becomes nullified because the property can't be developed because it won't have access. Or you can deny the application because you question whether the access is sufficient and can't make the findings, or you can continue the application to give the applicant the opportunity to prove or disprove, shall we say, the neighbor's contention with regard to the easement. You have all of those options.
Yes, Commissioner Erickson.
Could you, this is a technical legal question for the attorney. Are there conditions under which the grantor of the easement could withdraw that grant in the easement agreement at their initiation?
There's nothing that's present in the agreement that gives them the right to cancel the agreement.
Let me also just make a comment on this. I'd like the town attorney to listen to and see whether it is correct. My understanding is that we have advice of our counsel saying that he believes the easement is valid and subsisting. The fact that something can be attacked now or later really, to me, is kind of neither here nor there, unless you had some reason on this legal question to doubt the advice of counsel. You obviously don't have to follow the advice of counsel. I personally have no information which would lead me to believe that our counsel is wrong. On the other hand, I'm not sitting here saying the counsel of the other party is wrong, but typically I would follow my own counsel's advice. That having been said, it will be interesting to see how this develops during the course of the evening, and I'm sure there'll be some questions on it. So are there other questions of staff? There not being any, and the full complement except for the one recused commissioner, we can proceed. So I would ask for the applicant to make the applicant's presentation.
Tony Jeans, 170 Stacia Street, Los Gatos, on behalf of the Moffats. So project summary to date is fairly well identified. You originally had a small lot at a building site with a 30% slope. with a significant tree potentially impacted and an increase of traffic on Francis Oaks Way. You denied it. Based on lot size issues, you were concerned that it was a 2.5 acre minimum and it was a 1.2 acre lot that was suggested. And you said it was inconsistent with the zoning code, therefore. And also slope and tree issues made the site not physically suitable for the proposed density or type of development. That was what you did. The council sent it back based on a willingness by the homeowner to adjust the lot size, but also with direction to the homeowner to bring it more into compliance with ordinances. The revised application that is here has a 3-acre lot instead of a 1-acre lot. The building site is almost level. There are no trees impacted. There is no impact on Francis Oaks Way, and it has support from a significant number of Francis Oaks Way residents, and you have that list in your report showing some of the ones who have said they're happy with it. I'm going to jump straight to what I think I have to do, which is explore the findings by which you can deny this and show you, I hope, that they are all clear. You can't deny based on any of them. The first two, the staff report, it says very specifically that the map is consistent with the general and specific plan, and that the subdivision is the same, the designer improvements. We then have two areas that I want to address by exhibit. One is the type of development. Can a reasonable development be done on this site? And in roughing this out, I took the maximum floor area ratio that you would allow on this site at 6,400 square feet, including a garage, and said, how would I place that here? And that's what I've done. You have a 3,500 square foot footprint, which is here, a main floor of 1,700 feet, a cellar basement area of about 1,000, and a garage of 750 feet. That's what I've drawn, the garage, a cellar area, a main floor. Upstairs, I have 2,200 feet because I want to step the upstairs in from the lower floor. I don't want vertical walls, 2 stories. And then I put a little 650-foot guest cottage out there because I think it would be cute nestled in the trees. So this site is entirely developable within the framework of the site itself. It gives you a rear yard of 1/4 of an acre plus trails all over the place. That deals with the site being physically suitable for this type of development. Now let's look at density. This is the real Exhibit 1. You have an Exhibit 1. This is my version of Exhibit 1 because the version that you have just had this as a big blank area. But this is the Highlands subdivision. If you just generally look at this, you'll see that here is the 3-acre lot, and it's entirely consistent in terms of density with all the neighboring areas. So I don't think you have density as an issue when you're looking at this particular project. In terms of neighborhood compatibility, you have a plan on the wall. I'm just repeating it here. The house would be accessed up Shady Lane. There will be a driveway into this parcel, just like there would be a long driveway up to Lot 4. There would be a long driveway to Lot 9 on the Highlands subdivision. It's entirely consistent with the area around it, and it would really fall in part of the immediate neighborhood of the Highlands development.
Would you please wind up? You will have your...
The one last area that you need to look at is, are there any easements that are potentially impacted? These are the easements on the property to the public at large, a right-of-way, a storm drain, and a proposed scenic easement. None of those is impacted
Mr. Gene,
by this development.
I hate to do it, but I am going to have to cut you off for time. But I have a feeling that the questions, because they've been raised, will get into the easement issues, and I would invite the commissioners now for any questions they may have of the applicant. Seeing none, we'll look forward to Commissioner Machici.
What other evidence do you have that supports the non-denial aspects of this?
What are the, what
What other
evidence?
statements or comments do you have supporting the non-denial aspects of the findings?
I addressed the three that I thought were potentially discussable, that it's physically suitable, I showed you the plan, that the density was appropriate, and that the design of the subdivision would conflict with easements. I don't believe it will. The rest, the other two, are addressed by the initial study and the mitigated negative deck as to whether there are health issues and migration of animals and such like, fish and wildlife. So I think you're covered, and I don't believe there are any areas by which this should be denied in the subdivision map act list.
Thank you.
Other questions? Thank you very much. The next speaker I have is David Fox.
Good evening, everyone. I'm David Fox, 479 North Santa Cruz Avenue, Los Gatos. There is a spirit in a letter to every law and ordinance when they are applied. The hope is, I believe, to produce a decision that complies with the letter of the law, but also meets the spirit of that the writers intended. And this is never so important as when a governmental body approves a home for building. There are very few projects that affect the quality of people's lives more than the homes they live in or the homes that they live next to. And the application before you, in my opinion, only meets half of that goal. If you look at the plans, you could say and make the argument that it meets most of the criteria of the town of Los Gatos, and it could be seen as being technically compliant. But I think that just like the Highlands was held to a higher standard, I believe this lot needs to be held to a higher standard also. It's a very restricted building pad, so much so that it's wedged between an easement and a 30% slope. And the house as staked on the lot is right up against that LRDA, that 30% slope, so much so that if they had to do any over-excavation for drainage or a footing or a retaining wall or anything, they would be creeping into the LRDA. So in fact, they're going to have to move the house more to the north because they need room for all of those things. The entrance to the home passes through a piece of land that does not belong to the house itself. Therefore, the people that own this property eventually will have no say as to how the property is landscaped in front of their home, nor will they have any say as to how the fence is put up. If Mr. Harris, who owns the Highlands of Los Gatos, decided to leave it in dirt, then it would be dirt in perpetuity, and they would have dirt leading up to their home. So to say that it is part of the Highlands neighborhood is a misnomer, because just as easily Mr. Harris could put up a 6-foot fence, a 30-foot hedge, you would never see this house and it would have no connection to the Highlands at all. Because of the way that the easement works and because of the way that the lot is situated, I believe that it needs to be considered, where are you going to park the construction trucks that are going to have to build this home eventually? How are they going to be staged? How are the materials going to be staged? During the PD process, the roads were restricted in width in the Highlands development. Therefore, you cannot park against the curb and still maintain two-way traffic. In addition, the streets of the Highlands are not public yet. They are still private. So therefore, there is restricted access. One other thing, even though all of the utilities are in at the Highlands, they are not active. And they will not be active until a home at the Highlands is built. Therefore, this lot is going to be at the mercy of the timeline for the Highlands. There are certainly restrictive lots in town, and I've worked on a lot of them myself, and this house It's isolated behind a fence designed by others, with an entrance that cannot be beautified except by others. There's no identification at the street because you can't put in a number. It's at the bottom of a ravine with an easement running through it that severely limits the outdoor space. I think that there are probably better places to put a home in this area. I just do not believe that this is one of them. Thank you very much.
Thank you. Are there questions of the speaker? Thank you. The next card I have is Dennis Brown.
Hi, I'm here actually for rebuttal on legal.
All right, thank you. Thank you. Citizen Ray?
First off, nice to see Ms. Rooney back. Ms. Rooney, I got to tell you, this item calls to question the way you're running your department, okay? I've spoken to you before about the fact that you're making recommendations, usurping the power of the Planning Commission. And you make these recommendations, discretionary judgment, without even hearing one word from the public. Take down that red, white, and blue and put up a Jolly Roger, and then you do what you want to do. Shame on you. Now you're new, and you got to start listening, because this is not going to go away. The town code gives you no authority. I've researched it. I've asked you to show me where it gives you authority to make recommendations. You have failed to do so. So I'm going to turn the screw in harder and harder from here on in. Land use. Land use near creeks and streams. Evidently, there's a creek down below. It's a steep ravine. There's a creek down below. Okay? And I read all the literature. Talks about a riparian area, a riparian situation that has been raped because all the riparian growth has been taken out falsely, previously, and a year and a half ago, the town of Los Gatos received authority from the Streambed Coalition to handle land use near creeks and streams. And part of that authority is the concept of a riparian right-of-way. And Ms. Rooney knows this. She's failed to act on it. The town has drugged their feet, failed to act on it, and here we are in another land use near creeks and streams, and there's no town policy that dictates the size and quantity of the riparian right-of-way. And as a fish and game biologist by education, I got to tell you, that's where all the critters that we all enjoy live. That's how they move back and forth between various areas, okay? That's where they feed. That's where they do everything that a little critter does, okay? Possum, skunk, and so forth, okay? So, with no riparian policy on this property, how can you approve anything? I'm going to wind it up. It says right here, the town council directed the commission to review the application for compliance with all applicable town ordinances, standards, and guidelines concerning land development. Period. End of story, and you have failed to do so. Thank you.
Thank you. Next card I have is for Gary Harwin.
Gary Harwin, 15423 Francis Oaks Way. There's an important issue that has been raised that relates to this subdivision application. That issue has to do with an easement agreement between Sandy Harris of the Highlands Los Gatos project and the Moffetts that was originally entered into in 2005, revised in 2006, and finalized again in 2008. The apparent point of contention is whether or not the Moffetts are precluded from subdividing their parcel and passing the agreed-to easement rights to the new parcel. Sandy Harris apparently advised staff of his position on the matter, essentially stating that there existed a dispute over the status, egress, and ingress easements for a new building site that would use the Highlands infrastructure. It was made clear that a legal issue between two private parties over easement rights was developing. And here now enters Ori Korb, acting as judge and jury on a dispute between a grantor and a grantee. Ori proceeds to interpret the pertinent clause in an agreement as not precluding Moffett from transferring the easements to the new parcel. What I would like to know is exactly when did the residents of Los Gatos give Ori the authority to adjudicate a civil matter between private parties? Mr. Harris's attorney, Robert Kahn, a lawyer whose expertise and knowledge of contract and land use law is at least an order of magnitude greater than Ori's, has stated his opposing position to Ori in two letters, which you all have. Interestingly, the contentious clause, which was prepared by an attorney, was also included in a totally different easement agreement entered into in 2005 between 6 neighbors on Francis Way and the Moffetts, at the request of Mike Moffett. The purpose of including this clause in the neighborhood agreement was to prevent any of the 6 neighbors from splitting off any of their parcel and passing the easement rights that Moffett granted to the new piece. I included the same basic clause in a 2007 easement agreement between Highlands and the 6 neighbors, but modified it to specifically allow for the transfer of all easement rights to any parcel splits. I am requesting that Ori be instructed to immediately refrain from commenting in any way on private party disputes. The citizens of Los Gatos do not need to see their limited tax dollars and staff time squandered on defending against an action that should be resolved solely between private parties only. Obviously, this private easement dispute needs to be resolved between Harris and Moffett, without Ori's meddling, especially where such meddling could result in liability for the town. Thank you.
Just 1 second. Are there any questions of the speaker? Thank you very much. Next card I have is for David, is it Weissman or Weisman? Weissman? David Weissman, please.
David Weissman, Francis Oaks Way. I have laid out my thoughts on this proposed subdivision in 2 letters included in your packet. Despite my concerns regarding the ecological sensitivities of this area being summarily dismissed by Geyer and Geyer, I continue to support an interest in riparian restoration under the aegis of the Blossom Hill Open Space Study. Such concerns are additionally heightened when I learned that one weekend several months ago, apparently without permits, the Moffetts extended the 24-inch Highlands drainage culvert some 200 feet onto their property. I simply ask that you do as Tony Jeans requested. Make a determination of this project on its merits. I believe, as several real estate agents and developers before me have believed, and as are stated in the Hillside Standards, that site characteristics and constraints of these 8 acres do not allow maximum density or intensity of development. In support of such a determination, please read carefully Tony Jeans's 2000 statement in Exhibit 11 in your packet, given under oath and subject to charges of perjury. And I quote, "We conclude that this 8-acre hillside parcel only contains one viable building site for a home." End quote. Mr. Jeans, in Exhibit 15, now tries to spin that statement by saying the Highlands project has created a second building site. Does he actually believe that anyone has forgotten that in late 2006, he was before this very planning commission claiming a second building site adjacent to Francis Oaks Way, a location completely independent of the Highlands project? I believe this subdivision should be denied under criteria B, C, D, and E of the California Subdivision Map Act. The town's attorney is also demonstrating, perplexingly, a double standard. In the last 8 years, there have been 2 easement disputes between property owners on Francis Oaks Way who desired development. In both cases, the town took a pass on the proposed projects until the easement issues were worked out between the parties. Given the reasoning of the Highlands attorney, I am at a loss to understand why the town's principle of non-involvement has been abandoned now. Thank you.
Thank you. Are there questions of the speaker? Apparently not. Thank you. Those are all of the speaker cards I have for other than the applicant. There being no other speakers, I would invite the applicant to come forward for rebuttal.
We have 3 minutes for rebuttal.
You have 3 minutes. That's up to 3 minutes.
No. I think everything is pretty well addressed in the documentation that you have before you. There are many things that I could bring up, but to do so is just reiterating what you already have in front of you. I think Geyer & Geyer has responded very well to Weissman's original letter, and I think Exhibit 15 responds to his subsequent one, and there are additional responses as well. Specifically, the study and the negative deck state that there is no riparian area there. I'm going to pass a document to you shortly that I'm going to be prepared to answer questions on, but really what I want to focus on, I think, is the easement issue, so I'm going to ask Dennis Brown to come up and talk about that as part of the rebuttal. In the meantime, I'm going to pass this document out. This is a series of questions.
Mr. Jeans, I would suggest while you do that, we let him speak because you're going to run out of time.
Okay.
Mr. Brown, would you go ahead?
I need one.
Good evening to all of you. I'm Dennis Brown. I'm an attorney from San Jose. I live on Varner Court in San Jose. My office is downtown on Market Street. There is no legal issue here about that easement. I was involved in that, in the drafting of it. It was very clear. When you have an easement, as the city attorney has clearly opined, and it's an appurtenant easement, as this is, it runs with the land. It specifically states in the easement that it runs with the land. And as such, while you cannot separate the easement from the land, there is no restriction in the easement that prevents you from separating the land and having the easement run with each portion of it. Theoretically, you could have 20 lots there. Every lot is part of the whole, and the whole was granted this easement. Moreover, this second lot that's being proposed benefits those who gave the easement. So while the second lot that's proposed derives this benefit, it also confers a benefit, which also makes it bilateral. It gives and it takes. So in addition, while it's not required, the second lot actually gives and in return gets the access to the easement. It's not a legal issue at all. And I think the fact that they bring up the prospect of litigation, that's simply to try to influence you unfairly to consider issues that are really not before you. It's a subdivision application, and there is no legal issue. They haven't filed, and if they did, they'll lose. Questions?
Yes, Commissioner Jensen?
Mr. Brown, leaving aside the question of whether they'll lose or not, are you in communication with Mr. Kahn regarding this easement dispute, and is there some kind of dispute resolution that's going on, whether a suit's been filed or not? I'm concerned about the issue.
I have not spoken to him, and there is no ADR, no alternative dispute resolution discussion.
Commissioner Sack?
I appreciate your being here because I definitely do have several questions.
Great.
And some of them may be very simple, so I'd appreciate you just kind of walking me through the whole easement issue. In the documents that have been submitted to us, and I hope you had a chance to review them, one of the issues was that the grantor of the easement claimed was that it was a secondary easement. A secondary convenience easement is the words that I underline, so that it would just primarily be accessed in case of emergency, or for emergency was the example. Is there a difference between having a secondary convenience easement versus just an easement? Can you just explain that?
First, there is no such restriction within the language of the easement. It's not considered for simply emergency purposes. It is a grant of an easement for a roadway. Secondly, easements are restricted in the language that's used in the easement. If there is no restriction on the face of the easement, then it is unqualified, and that's the case here.
A
And
follow-up
then-
question?
Yes, and then my second question, aside from roadway and driveway access, does the easement also incorporate drainage issues? Because the reason I ask is in the initial study and the mitigated neg deck, one of the issues that is raised is the runoff that will come from Lot 2 and how it would affect Ross Creek and I believe, what is the other creek? Well, the second creek there. And that is going to be addressed by the sewer system that is on Shady Lane. So the question I have is, what kind of easements would Lot 2, should this be subdivided, have with the Highlands development? Is this an easement that was also agreed upon?
I'm probably in a better position to answer that. There are two areas of the easement, actually three. One is ingress-egress, and the second is for full public utilities for the entire Moffett property. So that means sewer can go out, electricity can come in, water can come in, and because there's a storm drain easement that actually benefits the Highlands property, if you read the Fletcher's document that was an email back from Fletch, you would understand. Water can go out. However, there is a requirement as part of the mitigated negative deck to try not to increase the amount of runoff from the property, so various tricks will be used, such as retention pools and bioswales, to try to allow as much of the water that is on the site to stay on the site and not run off, and to try to keep the footprint of the house and the impervious coverage to a minimum. So we would propose permeable pavement or pavers, for example, for the driveway. But that's an A&S issue, which, again, we have to deal with Trang over, and she would come all over me if I allowed excess water to run off.
Go
So
ahead.
then, I'm going to summarize what you said. Thank you for the explanation. Basically, it is your opinion that the easement that the Moffetts have does incorporate not only egress, ingress, but the environmental conditions that are addressed?
Indeed, everything attendant to the appropriate installation of a road is part and parcel of that easement.
Okay, thank you.
Any other questions? There are no other questions. Thank you.
Thank you.
Are there any questions on the document that was the email to and from
You know, if we could
Mr.
take
Parsons?
perhaps, let me stop you for a second, because we just got this. Let's take a minute, perhaps, and make sure we all read it to see if we do have any questions. Did everyone get a copy of this? Okay. It's just, we'll take one.
It was done to deal with the storm drain issue. That is the basis of my giving it to you. There are some issues
Let me stop.
that are not storm drain related.
I don't want this to be disproportionate, so if you could just be quiet for a minute, let us read it. If there are questions, we'll ask them. If they're not, we'll move on and close the public hearing.
How about the public? Don't we count?
I thought I already heard from you.
Thank you.
Didn't I hear from you?
New evidence.
That email is on file with the town.
Do you have any other copies?
I gave a number out, and Trang just...
That's fine. I just
I gave
wanted-
about 7 out.
No, that's fine. I just wondered if you had any more.
I don't have one in front of me.
That's okay. Now, have the commissioners had an opportunity to finish reading it? We're taking speed reading right now. So.
Why don't we get a copy of that?
I might just say for the record, I'm receiving this as rebuttal from the applicant. That's why it's not new evidence. We'll be glad to provide copies. And let's see if the commissioners have any questions. There isn't any, well, I won't characterize it. That's my view of it, is that Is there any reason to believe that we should reopen? Okay. All right, are there any questions? Yes, Commissioner Sayak.
Mr. Jeans, in one of the exhibits that you put up showing where the footprint of the house would be and how it is within the LRDA, one of the issues that was raised was that you are right against the edge of the LRDA as well as the 30% slope. And the issue was raised of how, basically, how are you going to accommodate any wiggle room should you need it to build that large a home on that particular site?
Firstly, I don't know what size home Mr. Moffett is going to want to do. I just wanted to make sure that the maximum size that you allow could reasonably be accommodated. And what you have is a building that's approximately 70 feet long by about 40 feet across. That's moderately large. What I'm purposely doing in my mind, remember, we're not at A&S level, but in my mind, I would build a concrete wall here, 10 feet high, and I would have no windows out the back, and out of the spoils from excavating for the pad area, I would backfill behind this area to give a flat area to walk out from the second story out around the house, and I would be keeping it away from the LRDA appropriately and just ensuring that I have a nice walkout area from the master bedroom. I don't see an issue, and in fact, when I laid it out, I'm not tight on that easement. If you had a look at the easement out there, you'll notice that I was able, within the framework of the LRDA in the same footprint, to tuck it a little further in here to leave myself a 2 or 3 foot gap. I think I've got enough wiggle room. I'm not worried about it, but that is something that would have to be monitored during construction, as it is always. And engineering has the responsibility of doing that, and I think they do it very well.
Is there a follow-up or further questions from the commissioners? Appear to be no further questions. Thank you very much.
Thank you.
Did we receive other copies of that? Okay. Fine. I'm going to close the public hearing and invite some discussion or a motion from the commissioners. Commissioner Sayak, our questions, as I...
Actually, it is a question, and again, it is related to the easement. There is, in one of the public testimony submitted on record, was a question of whether, I wish I could... Yeah. It was a calculation of how much square footage is allowable if you take away the easements. And the question was taking away public versus private. If
I found it.
Are you talking about slope density calculation?
Yeah,
I think
it's
you're
on
talking about lot size.
Lot size?
Exhibit 11, and it's second page. It's not numbered, but it's Exhibit 11, and it's the second page. It's number A, 2A.
Yes.
That was going to be my question, too, so I won't have to ask it.
That is referring to slope density. We don't deduct easements when you're calculating slope density. It's based on the gross land area. The only thing that does come out is riparian corridor, of which there isn't any on this property. That was determined in the report done by H.T. Harvey. And if we had public right-of-way, that would come out. That would be the only things that would be deducted out from the property to do the calcs. And we have neither of those in this site.
I had a recollection that Mr. Weissman had raised a point, and it wasn't on slope density, it was on the size of the lot. That is, we started with a gross area, and that is to be subdivided, and we had numbers assigned to each of the lots, and I believe his point was, do you deduct from that anything in determining essentially the gross area as necessary? And I think he suggested that you did. So I can't find that either, but it is not my recollection, and I could be wrong, was there may have been a slope density issue, but there was also just a gross size problem. Does anybody remember that?
I do remember
Could you respond to that, or do you believe that's not an issue?
Well, the zoning requires the lot size to be at least 2.5 acres, of which it is. So,
But in determining that it is 2.5 acres, how do you do that other than survey the boundary of the property? Do you subtract anything once you do the boundary survey?
no.
Okay, so the answer to the question then was no, you don't deduct easements. Okay, thank you. Are there other questions? Are there comments, discussion? This is something I think we could all benefit by some discussion from the commissioners. While you're all thinking, I'll give you something to hit back on. I'm very troubled by the application, and I'm troubled by the application because it tries so hard to find another buildable site. It's a very unusual, it ends up being a very unusual site. And one of the, some of the things that are required of the State Subdivision Map Act is, let's see, well, it's suitable for development, not physically suitable for the development, not physically suitable for the proposed density of development. We had a lot up on Francis Oak, and of course the Francis Oak people aren't against this because it really isn't on Francis Oak. It's on Shady Lane. And we have this it is not a, it has this narrow access by easement, arguably making this a buildable site, and under certain circumstances it could. And the question is, are these the proper circumstances? So when you look at this, you have in my view, a somewhat tortured access to this property, and with that access, you could have a proper site. But I am very troubled as to whether it satisfies the requirements of the Subdivision Map Act. I don't go to this issue of what did they say before. We can just address it on, if you were looking at this, is it a reasonable expectation, if you were to buy this lot, that this was really 2 lots? And if that was a reasonable expectation, why is it a reasonable expectation? And if the proposal today is as it is, do you think that complies with the Subdivision Map Act in, for example, D and E? So I'm throwing that out for some discussion, and I'd sure like to know if anybody has any thoughts on that. Commissioner Jensen.
I agree with the chair. I don't think we can make, well, I should say a reversal. I think there are findings that are required under the Subdivision Map Act that we cannot make, and I agree that there's a question about the physical suitability of the property. I think Dr. Weissman has raised questions regarding the riparian habitat that are significant enough that we cannot make, or we can, I can't say it in the right way, but that such that Subdivision E, I can't get this straight in my brain about how to say it.
Well, you're saying there's not-
Subdivision E is a factor that I don't think is satisfied by the application, let's put it that way. I think that this matter was continued from our May 13th agenda to address specifically access and environmental issues. I think both of those issues are still before us tonight, and the public testimony has made that quite clear. As a litigator, this seems to me to be absolutely headed to litigation, and I don't think that it would be appropriate for us as commissioners, or at least me personally, I could not make the findings required as to access or easement or evaluate whether this property falls within the requirements of the Subdivision Map Act without having those easement questions resolved.
If I may, Mr. Chair, I just want to remind the Commission that in order to deny the subdivision map application, you have to make any one of the findings that are listed in Exhibit 4 of the staff report. I think that the points that are raised go to the fact that those findings, at least for some commissioners, may be possible to make. But again, it's a question of whether you can make a finding necessary to deny the application.
Okay, thank you for the clarification. I can make those findings based on the testimony we've had tonight as to E. And I think there's enough of a question regarding the access and easement to the site. I recognize that these are not public easements we're talking about, and I respect Mr. Corp and his opinions, but I think this is headed for court, and a judge is going to decide this. And for the Planning Commission to make recommendations based on what seems to me to be a legal dispute about access to the property upon which our decision depends does not seem to me to be particularly responsible decision-making, so I could make the finding for G as well.
Are there other comments? Yes, Commissioner Talasfor.
Yeah, regardless of lawsuits, we as a commission have to decide if this actually is a good parcel to subdivide and what its merits are. And that's basically what we have to decide. But when I look at it, I'm seeing that we are creating a subdivision based on easements. So I'm looking at driveways going into the other lots as regular driveways, and then I see this little road easement into this lot, and I'm thinking, okay, we're creating that. It's isolated. It doesn't have relationship to the homes on the surrounding properties, and there's no direct street frontage except for this easement that's there. So I have a real problem with determining that there's merit with subdividing it at all. So that's where.
Are there other comments? I just want to be clear in our consideration that were there no riparian issue, were there no litigation issue, I would still have the same feeling. That is to say, I believe the lot is, if you look at, I think it's D and E, the site is not physically suitable for the proposed density of development, namely that this parcel would not, this lot, original lot, would not support the two parcels proposed. That it's not physically suitable, and it's not physically suitable on the density. If you can just do that, I believe that you can separate all the issues which are somewhat hypothetical. I don't believe that we are involved in determining whether the easement is good, bad, or indifferent. We have advice from our own attorney that it is satisfactory, and I'm prepared to take that advice without saying that it's right, but you've got to follow somebody's advice, and I would like to continue believing that our attorney is the person we ought to follow. As far as the riparian matter is concerned, again, we have, certainly the evidence on the record is that apparently prior to the present owner, that is to say of the subdivision below, some things were done to what would have been a riparian corridor, which may no longer make it a riparian corridor. But again, I don't need that, because if you can find that just based on what they've got there, this, I believe, somewhat strangely designed, I don't mean that in an insulting way, it's ingenuous in a sense. Ingenious is the right word, I think. Ingenious in a sense. But it's a very, very difficult lot, and I think, why do we have to strain so hard to get two parcels out of this? What is the motivating factor? And I think I come down, you don't need any of the speculation. You can, on the record, on the facts, deny it on the basis of that you can make a finding that it's under C, and you can make a finding in D. I only say that, so assuming that this were denied and it is appealed, I want it fairly clear to the town council that we aren't getting into the speculation game, that we aren't disregarding the opinion of our attorney, because if I were the town council, I might think my attorney has a better legal opinion than my planning commission does. So I throw that out for your consideration and invite a motion. Yes, Mr. Micici.
I agree entirely with your aspects on the easement and so forth, but the thing I'm having trouble with is, in my own mind, I said, if I were to try to deny this, how would I state that something is not physically suitable when physically they've presented something that can go in there, regardless of how difficult it was? All right. So I'm having trouble. I would have trouble with the words in denying that. I would need some help on that to do that.
I'd invite you to the word suitable. That is a word of judgment as opposed to a fact. So I just invite that for your consideration. Are there other comments or questions? Commissioner Erickson?
I think I would basically agree with what the chair has said. It seems like to me that we're forcing development on a parcel that reasonably could be judged not to be suitable because we're forcing it into the situation. So it seems to me it may not meet the test of being suitable for the kind of density or type of development that's proposed.
May I ask if someone would like to make a motion? Because we can talk this thing, I think we've gotten people's opinions, so could we get a motion? I hope so. Commissioner Sayoc.
Okay, I'll take a stab at this. Okay. I move to deny subdivision application M064, located at 15500 Francis Oaks Way. I can make the following findings as required by Section 66474 of the State Subdivision Map Act. Based on the deliberations that have been stated by the commissioners and that I completely agree with, I find that C, that the site is not physically suitable for the type of development, D, that the site is not physically suitable for the proposed density of development, E, that the design of the subdivision or the proposed improvements are likely to cause substantial environmental damage or substantially and avoidably injure fish or wildlife or their habitat, and G, that the design of the subdivision or the type of improvements will conflict with easements acquired by the public at large for access through or use of property within the proposed subdivision.
Is there a second? I have a question then of the maker on G, when it says the easement acquired by the public at large, what easement do you have in mind?
I would have to say that based on the evidence presented, okay, let me step back for that. The exact wording is, it is still unclear to me, and I can amend the motion if others feel it, that the easement intent has not been satisfied. If it is the advice of our attorney that the intent versus the actual language of public is something that can be misconstrued, then I would strike that.
Mr. Korb?
I'm not absolutely certain, but I believe that G is intended to deal with situations where the proposed subdivision will conflict with existing easements, such as, for example, a utility easement that may be run across the property in an area that is proposed for development as a result of the subdivision, or where a road would be located as a result of the subdivision. I don't think it really is intended to address the issue that is raised with regard to whether access exists or not to the extent required for the subdivision.
Okay. Then I would amend my motion to delete finding G and just stick with D, E, and, let's see, I'm sorry, I changed the page, D, C, D, and E.
The seconder will accept that amendment.
Thank you. Commissioner Machichin.
I'm having difficulty in how we're including E. I found no evidence that indicates it's likely to cause damage at this point. I agree with C and D, and since we only need one, unless you'd like to explain to me how you feel we've been given evidence to support that. I know you stated it, but what evidence have I seen that supports that?
The evidence that I choose to use when making this finding is just there's still some unanswered questions on my part on issues that have been raised by a public citizen over what is that parcel of land that will ultimately be the driveway. There's still some ambiguity whether or not it's riparian corridor, and that certainly wasn't answered in my mind.
May I ask the attorney a question? If we use multiple reasons for denying this, is it not sufficient that if one of them survives? In other words, if a commissioner says, well, I only agree with 2 of those, I don't agree with 3 of those, or I agree with 1 of those, but I don't agree with 3 of those, if the motion passes, is it not sufficient that one of those survives, for example, review by the city town council?
Let me say that any one of these grounds can support a decision to deny. So so long as there is evidence that supports or that is incorporated into the finding, then that finding is sufficient for purposes of the decision. Reasonable minds may disagree about whether that evidence supports the finding, but so long as there is evidence, I assume the evidence that Commissioner Sayoc is referring to with regard to E, the environmental damage finding, is the testimony of Dr. Weissman and the documents that he previously submitted, arguing that that there may be a riparian corridor in the area that the driveway is proposed to be, based on information that was produced in a study back in 1989.
Yes, Commissioner Jensen?
As the seconder of the motion, I would suggest to Commissioner Sayoc and Commissioner Machici that E is, as I read it, it's written in the disjunctive so that either the improvements are likely to cause substantial environmental damage or substantially and avoidably, I would focus on, injure fish or wildlife or their habitat. So to my mind, the evidence that we've received and the documents from Dr. Wiseman raise a question about or support a finding that if we allow the development and the subdivision, that there could be a substantial and avoidable injury to a wildlife and fish habitat, that being the riparian corridor.
Other questions or comments? Commissioner Erickson.
Just a question of clarification. So in voting for the motion, are we acknowledging individually that there's evidence to support denying on all three grounds, or just one or two or three? You know the question.
The motion includes all of those findings. If you vote on the motion, then you are supporting all of those findings.
Let me say this, as someone once said about that. I personally believe that if there are, one of my fellow commissioners makes a motion on three grounds, and I agree with two of them, or I agree with one of them, and I were to vote in favor of that, I believe that if the council finds that one out of three of those is adequate, they cannot grant the subdivision, which would satisfy me. And by that, I guess I mean if one doesn't agree with C, D, and E, but agrees with C or D or E, we can slug this thing out until we wind up on what we all agree on. But I don't see why, if you did all three, even though you only agreed on two of them, it wouldn't work. So that's just my thought.
I would suggest that we make a comment regarding that.
For the record, yeah, sure.
So the council can understand where we're coming from.
Let me ask this then. Yes, I personally, and council can correct me if I'm not merely misguided but wrong. If you want to, we can run through it and see whether people agree, just for the record, so that the council might understand whether we all agree with all three of them or less than that, because I certainly get a sense that this denial will pass this evening. So let me start with Commissioner Erickson and move this way.
I would be supportive of rendering the findings at C and D, but not E.
Thank you. Commissioner Jensen.
C, D, and E for the reasons previously stated.
Commissioner Sayoc.
C, D, and E as the maker of the motion.
Commissioner Machici.
C and D, not E.
Commissioner Talaspour.
C, D, and E for the reasons given. I think that was very astute to look at avoidably injure fish or wildlife or their habitat.
Okay, and I agree with C and D and not E. So now, unless there's something further, we have a motion and we have a second, and I would call the question. All those in favor of the motion say aye. Aye. Anyone opposed? And we have one commissioner recused, so it passes 6-0-1, I guess is the ball score.
Anyone dissatisfied with the decision of the Planning Commission may appeal the decision to the Town Council. The appeal must be filed within 10 days. It must be filed in the clerk's office upstairs. There are fees for filing an appeal.
All right. Let's take maybe a 3-minute break. It's kind of warm in here. I'm going to walk outside for a minute and get some air. So about 3 minutes. All right, I'll call the meeting to order, and we'll start with item 3, and I'd ask for the staff report.
Good evening, Commissioners, ladies and gentlemen. The existing, item number 3 is 930 University. The existing site is located on the east side of University Avenue, approximately a quarter mile south of Lark Avenue. The site was previously owned by Verizon, who currently owns and occupies the adjacent parcel to the south, which also gains access from the existing access on University. The existing site contains a parking lot that was previously used by Verizon in their operation of their maintenance facility. The applicant's requesting approval of a zone change from CM to CMPD for construction of a self-storage building with an on-site caretaker's unit. Plan development application's been filed because the general plan encourages parcels in excess of 40,000 square feet to be processed as a plan development. Additionally, the applicant is requesting 2 exceptions to the town code. The 2 exceptions that are being requested is, first, the on-site caretaker's residence. In the CM zone, the zoning code doesn't allow residential uses in that zone, so that's the first exception. The second exception is to the front setback. With a proposed 35-foot tall building, the front setback based on town code would be 40 feet. The proposed setback is 12 feet 3 inches. This project is subject to a number of guidelines and standards, obviously the general plan, zoning code, and also the common design guidelines of the commercial design guidelines, which is pages 9 through 14 of those guidelines. Those are applicable to every site within town. Staff's provided information in the staff report regarding the mass and scale of the proposed building. Staff believes that the mass and scale in this particular case is appropriate, and the determination, the reasoning for the determination are outlined in the staff report. Staff has also provided information regarding the development on the existing commercial properties that are adjacent to the site. The proposed project will have the third largest square footage total. However, the FAR will be significantly larger than anything in the immediate area. Should be noted that the CM zone actually doesn't have an FAR requirement. The only requirement is a coverage requirement. The maximum coverage in the CM zone is 50%. The proposed application has a coverage of 38.6%. The consulting architect has reviewed the plans, and his comments for the actual architecture, he had no recommendations other than the removal of a potential sign on the building, and his additional recommendations, which are outlined in the staff report, related more to site planning. Adequate parking has got to be provided, obviously, for the site. The town code doesn't have a specific requirement for self-storage buildings. As a result of that, the town had TJKM conduct a parking study, parking analysis, and their determination was that the 14 proposed sites would be adequate to meet the demand of the proposed project. TJKM also prepared a traffic study, and the details of that are outlined in the staff report. TJKM concluded that the project is not expected to have any significant impacts on the nearby Los Gatos Street network or the study freeway segments. They did note that the Lark Avenue University intersection was at a level of service F, which is the lowest level of service there is. Obviously, this can't make that any worse. However, the other conclusion that they had was it will add, from their determination, 1 car to the existing queue, and they felt that that was not significant either. Due to the traffic impacts, community benefit is required. The applicant's proposing to replace the existing incandescent bulbs with LED bulbs for approximately 26 trees, which would be in between on Main Street, east of the Highway 17 bridge. The project was also reviewed by the town's consulting arborist on 2 occasions, and the applicant had retained Barry Coat to both prepare the initial evaluation and the response to the arborist comments. 22 protected trees are proposed for removal because they conflict with the proposed development. The applicant's also proposing to remove 4 trees in the town's public right-of-way, which is in between the building and University Avenue, and 1 non-protected walnut tree in that same area. Additionally, the impacts from a proposed retaining wall along the north side of the property would necessitate removal of 2 eucalyptus on the property that is to the north on, again, staff has determined that this isn't necessary. The trees in the right-of-way aren't necessary for the proposed development. However, the arborist did state that the removal of those trees could help the existing trees, oaks, that are on the site grow in a better fashion. And the 2 eucalyptus, staff has spoken with the arborist, and we feel that we can utilize a foundation system, probably pier and grade beam, for that area to avoid impact to those trees. The proposed project will require approximately 11,210 cubic yards of cut and 2,100 cubic yards of fill. 8,350 cubic yards of the cut amount is for the proposed cellar element. The proposed project is located adjacent to property that contains Los Gatos Creek, which the Santa Clara Valley Water District has fee title to. As a result, the guidelines for land use near streams are applicable to this site. Staff has reviewed those and looked at the potential impacts to the Santa Clara Valley Water District's property and determined that the project will not have an adverse impact on that area. Initial study and mitigated neg deck have also been prepared for this, and all the mitigation measures have been included in the performance measures of the draft plan development ordinance. In conclusion, staff believes that the Commission should carefully consider the requested exceptions, which is the on-site caretakers unit and the front setback exceptions, the mass and scale of the proposed building, neighborhood compatibility, the proposed community benefit, tree removals, and the proposed landscaping when formulating their recommendation to Town Council. The Commission also should consider consistency with the general plan, the common design guidelines of the commercial design guidelines, and the guidelines and standards for land use near streams. Staff's carefully considered these issues and believes the Commission should forward the project to the Council with a recommendation of approval. Alternatively, the Commission can forward the project to the Council with a recommendation of denial and provide direction on the issues that they feel are necessary to address, or the item could be continued with specific direction to a date certain. That concludes staff's report. If anyone has any questions, we're available.
Commissioner Jensen?
Sorry. Mr. Paulson, or whoever is appropriate to answer this question, regarding community benefit, would you help me in interpreting the town policy? I wonder, does there need to be a nexus between the property and the community benefit offered, such that installing lights a good distance away from the actual project is within the policy to find a community benefit?
No, the policy doesn't require any nexus between the impacts of the project or any aspect of the project and the community benefit that is offered by the applicant. Remember that if there's an impact associated with the project, then there is mitigation required, and there has to be a nexus in order to require that mitigation. Community benefit is a completely separate requirement of the town. I should also add that by recent adoption of the town's policy regarding gifts and donations, the council directed through that policy that the staff recommend and the council ultimately adopt, I think as part of the CIP process, a list of kind of a wish list of items that could be anywhere in the town. That's a list that would qualify for consideration by any applicant as a community benefit for that very reason.
Commissioner Bourgeois, you had a question?
Yes, I have a couple of questions. Just to be clear, the front setback we're talking about is the west side on University Avenue. That's the front, correct?
Correct.
And so moving that building further away from University would pretty much limit any ingress and egress out of that. I mean, flow of traffic in and out of that site is the reason why the building has to be pushed back that way. Is that correct?
That is one of the reasons.
Okay. What are the others?
Well, the other are that, as outlined by staff, this went to the CDAC. They provided comments. This issue was addressed, and the consensus of the Conceptual Development Advisory Committee was that in this case that was appropriate given the existing site circumstances. The physical restraint of the access is really the ultimate limiting factor.
All right. And if I may, another question on the caretaker unit. When we have other storage facilities that have caretaker units in town, are they in the CM zone and were exceptions granted to them?
The other one that comes to mind directly is in the LM, which LM does allow the potential for caretaker's unit. That project was also done at a planned development level and also contained additional residential apartments.
And is that a CMPD?
That is an LM.
LM, okay.
Other questions? Commissioner Erickson?
A couple of questions, Joel, if you don't mind. So if I understand the material correctly, the setback on the Verizon building to the south is 10 feet, is that correct?
Correct.
Do you know the height of the Verizon building? And I apologize for not asking you ahead of time.
I do not know the height of that. I would assume it's somewhere between 15 and 20 probably. I think it's a relatively single-story structure.
Yeah. Thank you.
Other questions? I have a question. Commissioner Bourgeois explored this 12.5-foot setback and the issues of why, and one of the reasons, as I understand it, is an access, but wouldn't that access, or would that access be solved by making the building smaller?
That is a possibility.
Okay, so what we're saying is if you adopt this building, then you have an access problem. If you don't do this building, you may not have an access problem. Okay, I'll be clear on that. Any other questions? There being none, I invite the applicant to come forward for the presentation.
My name is Scott Wyckoff. I work for Extra Space Storage and appreciate the opportunity for you taking the time to review our project. This is a project that we're very excited about the architecture of. We spent a lot of time designing it and responding to comments from the CDAC committee as well as the consulting architect. I wanted to clarify one thing. On the exhibits that are behind you, the ones that have the multiple trees is what the proposed project is, with the removal of the trees as discussed in the staff report. We created these exhibits just because you really can't see the building very well from the road, so we created these so you could actually see the architecture and structure of the building. So those are for reference, but what it will look like coming down the road is here. And we've created a model to show you what it looks like driving down University Avenue so I can identify the scale. Like I said, in August 8th of 2007, we met with the CDAC committee, had a follow-up meeting on September 12th, and we've tried during this process to implement the design recommendations, the massing, the scope, the size of the project, to meet the recommendations of the arborist and the consulting architect. In fact, I have an exhibit here that might help. Even though the setback is only going to be 10 feet. There's a pretty large public right-of-way. The actual building will be over 50, I think it's 61 or 65 feet away from the edge of the asphalt. So the actual building structure itself is not literally 12 feet from the edge of asphalt. As you can see, here's the edge of asphalt. Here's the property line that is the public right-of-way. And then that's where our building location is. So it is consistent. And I have an exhibit here if you'd like to see it where I can show an aerial view of the Verizon building and the neighboring properties and how they relate to the street as well. So I don't run out of time. If we can, I'll go ahead and we'll start this little just to show you how this building looks. There's a significant drop-off from University Avenue when you go down into this property. And so it really hides the massing. And with our architectural design features and colors, we feel like it really blends in well with the environment. It's coming from the reservoir down University Avenue. This is coming in the other direction. As you can see in a minute, when you pull in actually to the office area, the office is actually on the second floor. So the only thing that they'll be above is like 1.5 stories would be above. In fact, if you stand across the street and look at the building adjacent to us, as you face the building to the left, it is actually higher, but our property does drop down, and they're pretty close to the same scale and size. Okay. And in response to, we've been excited to work with the arborist. If there are trees in the right-of-way they recommend we take out, we're willing to do that. We don't have to. We'll leave the trees in the right-of-way. There are certain trees we do need to remove and mitigate for, as it's mentioned in the negative declaration there. We have with us today, too, our architect, Craig Mann, is here that can answer any questions. And as far as the size and the scale, we've tried to design a project that fits in, blends in, and is still financially viable for us to build and to be able to keep on the property and the project site. Thank you very much.
Are there questions of the speaker? Yes, Commissioner Jensen.
Thank you for your presentation. Could you please address why you think it's necessary to have a caretaker unit on site?
Just as a model, that's something that we try to do if it's possible. We do have facilities without caretaker units, but we like to have the manager on site because it provides, just there's some more ownership of the site, there's someone there, kind of the eyes on the street and the mixed-use feel for the property. And so it's just something that we would desire or like to have if it's possible.
Commissioner Bourgeois.
Thank you for your presentation, and I know you addressed this a little bit in your letter of justification, but could you talk about, you said you need, the mass of the building is so you have a financially viable project. Could you expand upon that a little bit and discuss whether you think there's the need for a storage facility of this size in Los Gatos, and why you think you need something of this size at this site?
Okay. A lot of work and effort actually goes into these sites prior to us purchasing and acquiring them. Extra Space owns and operates about 700 storage facilities around the country, and we have some pretty in-depth models studying the demographics and the data before we make a decision to purchase a piece of property. In my letter of justification, I just identified for the potential demand just the square footage of storage that's available per capita in the 3-mile trade area. And we feel like this is a market that's underserved because there's 3.59 square feet per capita in this area versus the national average, which is 6.86, the state average, which is about 5.5, and Santa Clara County actually has 4.32 square feet per capita in that same 3-mile as an average. And so with our project included and the existing projects in the 3-mile radius, there's still only a 3.59 square foot per capita. So we feel like it's a market that's underserved that we'd like to participate in.
I think Commissioner Stack, you had a question?
I appreciate your simulations. I like those. Do you happen to have any looking at your project from the Los Gatos Creek Trail?
Yeah, in fact, I don't have a simulation, but I have an exhibit I can show you. We actually walked the trail today again just to see how the boards looked, and there's a couple places you could see patches of it through the trees, but nothing over the top of the tree rings. This is an exhibit that shows the back part of the property. See that? I want to pass that right out. We've done a lot of things.
Oh, pardon me. Let me stop for 1 second. It'll help you if you take a mic. We can't hear you as well without the mic. It comes right out.
Okay. So this is one angle of the backside of the property. And you can see all the elements. We have balconies, we have a lot of timbers and wood, and we tried to use the color palettes that the CDAC recommended and what we took from their comments. If you turn that over, it's the same back view of the property from kind of the Verizon property side. This would be the Verizon property looking back, and you can see the treatments. Frankly, this is going to be one of the nicest storage facilities that we've built. I mean, it's going to be a gorgeous facility. And you can see from that other exhibit, too, that we're actually over 50 feet from our back property line also. This is a hard one to see. And 100 and something feet from the creek area, actually, there on the adjacent property.
Mr. Bourgeois?
Just to be clear, those last two exhibits you showed, they weren't from, I mean, they were from that side of the property, but they weren't from the creek trail. I mean, you can't see that much of the building from the creek trail.
No, absolutely. This is standing on the back of our property, just
so
looking.
the fence line to the
yeah,
creek
fence
is
line
at
or
your back.
the road behind the property, correct.
Commissioner Telesford?
Yeah, you can't see it from the creek.
Thank you. I know that I was on CDAC, and you've certainly come a long way in your design. But I'm curious because I know that you spent a lot of time, you just said tonight, and it says in your report, of trying to make the colors, how do you say it here? Well, you utilize colors that are appropriate to the area and the space. And yet I don't understand, and maybe your architect can answer this, and maybe it's a corporate brand thing that you have to have a red roof. But why would you choose, when all the other colors are so subtle, why would you choose red as your roof, especially because I believe the proposed photograph over on the one on the bottom is from the Creek Trail?
No, none of these are from the Creek Trail. They're
That
all
are?
from the front.
Okay,
correct.
where is that one from then?
Standing directly across the street. It would actually be the one directly behind you on the bottom, is what it would look like.
Okay.
But we just cleared the
My
trees so
question
you could see
stands,
it.
why would you choose red as your roof when you could have chosen brown?
Yeah, I mean, there's nothing, we don't use a red roof on every one of our projects. We just try to do it in keeping with what our interpretation of the CDAC's recommendations were. But we're flexible on those color palettes. I mean,
It's 3 stories, that's the other thing, and
correct.
to have chosen that color really stands out, so,
Okay.
all right. That's all my question for now.
Commissioner Jensen.
I just wanted to follow up on Commissioner Bourgeois' question. He had actually 2 parts, I think, to his question. One was why the facility here, which you answered. I think the second part of his question was why such a large facility? So in terms of the mass of it and how, as Commissioner O'Donnell pointed out, smaller building, bigger setbacks. So I was wondering why you wanted to have as many square feet as you have.
Well, as we've built other facilities, some of our facilities are 110,000 square feet or larger. So relatively speaking, this is a medium or smaller size facility. And it's just, with the cost of land and the amount of money we have to spend on the property and what we can rent storage units for, it just makes the project have a return that makes it viable so we can actually do it and build the facility.
Let me ask a question then. What is your nearest built facility?
We have several facilities in Campbell. I believe there's 3. And we have,
what are their sizes?
some of those are some of those are older ones we purchased. They're 66,000, I think, and I think there's an 86,000. We're doing one in San Jose right now that's 110,000. The new development projects we've been building, not ones that we've either acquired or purchased, have been between 80 and 110,000 square feet. Some of the smallest ones, they're like 66,000. But there's 2 right across the street from each other in Campbell. One of them is 66, and the other one is close to that same size.
Thank you. Are there other questions? Let me ask you one other question then on the public benefit. I'm not quite sure, when we're evaluating public benefit, all we have is you're going to put some lights in, which may be wonderful, but I have no way to evaluate that, and, a rather gross way to evaluate it is, well, what does that cost? There's no evidence in the record. I now know that you want to put some lights on some trees, and I don't want to denigrate that. That may be, as I said before, wonderful, but in evaluating it, I don't have anything I can evaluate it. Do I count bulbs? If I don't have some idea of the magnitude of what this is costing, I don't know what the benefit is. So you could take your option. Either I'm asking you to share with me some idea of why you think this is a good public benefit, or I'll turn to staff and say, how did they evaluate it?
Yeah, we worked with staff, and my understanding, and Joel, correct me if I'm wrong, is about $250 or $260 a tree, I think, to do the retrofit to the more energy-efficient light bulb systems. And so that equates to what, don't I do my math in my head, but about $40-something thousand, I think, something like that as a community benefit.
All right, that's very helpful. Thank you.
You're welcome.
Are there other questions? Did Joel want to say something?
Staff's initial evaluation, this came from the Parks and Public Works wish list, as Ori explained earlier. We're actually assuming that it's going to be approximately $25,000, just to clarify.
Okay. Well, we would accept $40,000, I assume. Okay, and that's on the record. So are there other questions or comments? Yes, Commissioner Sayoc.
Just 2 more questions on my part. The first, in the staff report, specific to grading, it's going to require 9,110 cubic yards will be exported from the site, and it talks about 8,000 of that because of the cellar element, and then another 2,500 because of over excavation and potential pavement replacement. Could you just explain what over excavation, what that 2,500 would be for?
That would just be around the perimeter of the building to get the grading and the slope for the drainage, as well as the realignment of the drive area and the office area.
And then actually, the second question I had, the town and our Regional Water Quality Control Board does prefer landscape treatment devices for on-site water treatment, and it states that you do prefer mechanical. Could you just state why the preference?
No, we don't prefer mechanical. We prefer to do the natural ways as well. I don't know that I can stand up here and tell you it can be a completely non-mechanical system with the constraints of the site, but that is our preference, and that's what we're going to desire to do.
Are there other questions? Thank you very much. I have one card as an additional speaker, and that would be Citizen Ray. I'll invite you up now.
Again, one man against the chase for the dollar bill and the elimination of Los Gatos as we know it as a small-town community. I watched the same kind of approach happen in Walnut Creek, where I lived 40, 50 years ago, okay? Once they get started, goodbye small town. They're asking for an 86,000 square foot building. I can't believe it. 86,000. Okay? Where are all the cars going to go? I mean, it's a commercial storage building, so I presume there's what, traffic in, traffic out, traffic in, traffic out. And look what they say. They say that the so-called expert we hired, the traffic engineer, however, they did note that the intersection at Lark Avenue and University Avenue currently operates at a level of service F. The proposed project will not degrade the level of service because level of service F is the lowest level. How do you like that for logic? Isn't that beautiful? This is a perfect example of what these people will say for a fee. They'll say anything, whether it makes any sense or not, for a buck. And so I'm looking at the staff over here. Again, they made a recommendation here to you to approve. They never heard one single word from the public. They made their deliberation in private with these developers, behind closed doors. They will steal Los Gatos right out from under us if we don't stop this nonsense. This is not Gilroy. I hope you understand, Ms. Rooney. Please show some evidence that you understand that Los Gatos is different than Gilroy or anywhere else you've been. It's a special place, and we love it just the way it is. We don't want you to rape us and change us.
Thank you very much. All right, the applicant now has time for rebuttal of up to 3 minutes. That was a short honeymoon.
Again, just want to reiterate that we feel like this is a great infill site. This is a use that really has a relatively low traffic impact compared to other uses that might be approved or acceptable in the in the existing zone, and we're available to answer any questions you might have.
Commissioner Telesfor.
Yeah, I have a question about you have 3 stories above ground, and then is that 1 full story underground? Can you explain that?
Yeah, there is a cellar element that is a story that's essentially underground, correct?
For storage?
Yes.
And it's the entire, it's not just a portion of the building, it's the entire building?
Well, it's not exactly the entire building, but essentially it is, yeah. It's the basic footprint of the building, correct.
Can I have
Please.
another question? And did you do any market research here in Los Gatos as far as how many other storage units facilities we have and the sizes of those?
Yes, absolutely.
Can you reveal those to me?
I don't have them right with me, but they may be in my packet if you want to do them out. But we go to every facility, we price shop them. Every week we price shop. Every month we price shop all the facilities within the existing radius of our facilities, so we know exactly what they're charging for their rates and what their occupancy is. So we've done that as well long before we even made a decision to move forward with this property and project. So yes, we have. We've surveyed all of those facilities multiple times.
Okay, thank you.
Are there other questions? Thank you very much.
Thank you.
All right, I'm going to close the public hearing and ask for a discussion and ultimately a motion. Does any commissioner have something to share? Did I see a hand? Okay. Commissioner Erickson.
Seems like a relatively reasonable use of the space and reasonable variances from the standards and the applicable guidelines.
Commissioner Bourgeois?
Yeah, I'd like to bring up an item that really wasn't called out by staff as one of the primary things we should be concerned about, but it's been the item that's been giving me the most heartburn on this project. And I talked to staff about this offline, but I want to just put it on the record. And that's the adjacent riparian corridor. And if you look in detail at the guidelines and standards for land use near streams, we aren't touching the riparian corridor. We aren't impacting, no direct impacts to riparian habitat. But it also does call for a riparian setback. And that analysis was not done. Looking at the siting of the building and adjacent uses, I think the front setback exception, pushing the building as close to university as possible, is the best possible siting of the building to move it as far away from the riparian corridor as possible. But in general, I think when we as a commission, when we voted on the guidelines for land use near streams, there's this 25-foot number that's in there. And one of our concerns was that that number would just kind of get pulled out and thrown at every riparian corridor that we come across. And they're not all created equal. This is Los Gatos Creek. This is this is one of the gems of our town. The creek trail and the creek itself are very important to Los Gatos, and so I'm concerned about lack of analysis of any sort of setback. However, I think the way the project is cited, and I looked at a detailed look at the planting plan, they did a very good job with using native and some riparian species in the planting plan. So I think they did a good job, but I'm just concerned about the analysis of that document. It's a very detailed and not always intuitive document to use, and we haven't had very many opportunities to apply it. So this being one of the first, I wanted to just express that concern. So that's one of my primary thoughts. And also, I would like to state that there's an inherent conflict between our tree replacement guidelines and the guidelines for land use near streams. We say you remove a certain tree, you have to replace it with 24-inch box, 36-inch box. Those are big trees, take a long time to grow. However, the Water District document says they have to be watershed specific. And I challenge anybody to find a 36-inch oak tree that's specific to the Los Gatos Creek watershed. It can't happen. So I think there's some inherent conflicts between our tree replacement policy and these guidelines. So that's just some of my initial thoughts.
Commissioner Jensen.
I share Commissioner Bourgeois' concern. More generally, I'm concerned that I understand that there's actually, I understood this only from Mr. Paulson tonight, because in reading the staff report, I had the impression that if a project was 40,000 square feet, a PD was required, but you said tonight that it was encouraged. So given that it's only encouraged, I wonder why this comes to us as PD, and why, and looking at page 4 of the staff report regarding why the staff felt that exceptions were appropriate, none of those, I have to say, seemed particularly convincing to me as to why to go outside of the existing guidelines. Commissioner Bourgeois is convincing with respect to the setback for the riparian corridor, but given that the applicant has indicated that, for example, the caretaker unit is desirable but not required, it seems to me that there's no real basis for an exception there. And there's no real basis for an exception to setbacks that are based on the size of a building in order to accommodate the applicant's desire for a particular size. I think if the town, from my perspective, if the town's requirements require a certain size to be put in specific setbacks, then a PD isn't designed to get around that. So that's where I'm troubled.
Does staff want to make any comments on that? Okay. Are there other comments or questions? Commissioner Sayoc.
Okay, one other issue that I would like to put on the record is alluded to it earlier, is the amount of grading that'll be necessary for the cellar element. Given the fact that the building height is already at its maximum of 35 feet, I am troubled by the amount of grading that is necessary for the cellar element. If you were bringing the building down and then had the cellar element, I could see the reasoning behind that. But having both the maximum height and the cellar element is where I'm finding some trouble spots with the current proposal. And I just wanted to put that on the record.
Yes, Commissioner Jensen?
This is, I guess, a question for staff or Mr. Korb regarding our options. Given the concerns that are raised, I just wonder, what we're supposed to do is either make a recommendation or not make a recommendation on two things. Do we have an option to continue and ask for investigation regarding the riparian habitat or the size of the building, the caretaker unit, or the grading?
Yes.
Are there other comments? I'd like to make a couple of comments then. I think the applicant did a very good job. That having been said, however, it is not an easy project to approve. And the principal reason I say that is the size. I was troubled by the 12.5-foot setback. Commissioner Bourgeois explored that, and I thought helpfully so. I do want to address a question to staff in a minute, because the applicant says, well, it's really not 12.5 feet to the asphalt, and that's obviously true, but I want to make sure the asphalt stays where the asphalt is, and I don't know what the town's response to that will be. In other words, it's all been our experience that sometimes roads get bigger. So if we're going to count on the fact that we can add on to the 12.5 feet, I want to know how long we can count, we can count on to that. I also agree with Commissioner Talasford that the color selection, and heaven knows I rarely get into color selections, but this color selection really hits me in the face, and this is a building that is well covered, but then to make the colors what I believe to be somewhat vivid kind of argues against what you're doing with some really good screening. Now, I don't consider myself any expert in color. I only share that with you. I don't tell you how to pick colors, although that could be an important issue. When I struggle with this, because if you're going to build, and you can build a really good building, there's no reason why it shouldn't be a building that accomplishes the purpose, so we don't need another building because we built a small building. There's some advantage in that. But it is an awfully big building, 86,000 square feet. It's in a nice location for an 86,000 square feet because it's essentially in a swale. I understand Commissioner Bourgeois' comment more directed, and maybe I'm wrong, and he can comment, more directed to staff than almost the applicant. In other words, this is the maiden voyage, so to speak, and we didn't get it right. But then he responds by saying, but, based on my observations of what I've looked at here, and I have great respect for Commissioner Bourgeois' opinion, it looks like it's okay. Now, maybe I'm overstating that, but if that were the case, then I think the message could be received and acknowledged, and the next time out, we would follow Commissioner Bourgeois' advice. So I would not be in favor of sending it back, because I'm not sure what we'd send it back for. But it seems to me we either ought to make a recommendation saying yes or no. Now, Commissioner Jensen talks about the caretakers, the residents there, and I happen to think that's a good idea. I think a big building, if it has a resident, it has some real advantages, such as making sure that somebody's always there. And I think personally think that's a good thing. The traffic study doesn't indicate that's going to hurt traffic in any significant amount. As far as the 12.5-foot setback is concerned, I think the critical issue there is to what extent can we say, but it's really 50 feet or whatever it is from the asphalt curbing. And if, in fact, we can't rely on that, then I think the building's clearly too big. So I need some help from, I'll defer in a moment and ask for an answer on that. And then Commissioner Jensen's final point of those two, I think, was a third point, which was the size, and I am troubled by the size. But I would rather see one of these go in than two of these go in. And if indeed there is a need for these, and I think there probably is, I don't know about this economy, but in general, then the argument that one is better than two may carry some weight. Enough said. I would now ask staff to tell us about the use of the city right-of-way. I don't mean that the applicant is saying you got to count that, but aesthetically, how long can we rely on that buffer that is owned by other than the applicant?
Well, currently, as stated, it's town public right-of-way, so the right-of-way goes all the way to the edge. Given the constraints of the vertical distance and the existing vegetation that is not only adjacent to this property, but the property to the south of Verizon, we don't believe that in the foreseeable future, and Trang, I don't know that there are any plans in the CIP or future CIPs to expand the width of this road. The challenges that would create, both monetarily and in terms of loss of vegetation and requirement of retaining walls to expand that road, I can't guarantee that will never happen. I don't think anyone would say that, but the likelihood of that happening, staff would say, is limited.
Okay, Commissioner Bourgeois?
If I could follow up on that, and is there a similar right-of-way on the other side of the street where there is no elevation difference?
That I don't know. I can check on that.
It just seems if you're going to widen a road there, you're going to go the other direction.
Right.
And I would just like to confirm the chair's interpretation of my comments. I think you understood me correctly. So
good. Thank you. Thank you. Are there other comments? Commissioner Telesfor.
Yeah. I see a discrepancy here, and I'm confused by it. In the 2008 answers to the CDAC from 2007, it says here most of the buildings on this end of University Avenue are 1- or 2-story buildings, and the response was the height has been reduced to 2 stories above ground and 1 below, which really answers that. And now I see, according to the testimony of the applicant, that we have 3 stories above grade and 1 story below.
I found the same
I'm worried
confusion.
about that. I think we have inadequate parking for an 86,000 square foot building as far as truck size, car size. I think it's inadequate. So I'm really questioning the size of this building at all. And I think if I appreciate what the new design looks like. You need to tweak the roof, and probably the bottom that's white down there. But because one of the things from the CDAC was that this really fit into that beautifully wooded area in that section. And most of the buildings in that section are 1 and 2 stories. And even though you're allowed to go to that height, for me, it would be problematic because it would really abruptly change the scale.
Other comments, questions, motion? Commissioner Jensen.
I'm going to try a motion because I actually think there's enough concern that there would be some value in asking for more information and asking the applicant to come back to us with a different design. So my proposal will be to continue this with recommendations and questions for the applicant and for staff. And staff would be, can we get the information that we've requested, or Commissioner Bourgeois has requested regarding the riparian corridor? Would the applicant give us a design which is considers not using a cellar to address Commissioner Sayak's concerns? Would they propose a design with color boards that doesn't have a red roof? Can we have more information about the necessity or desirability of a caretaker unit on the property? Because I don't think there's a lot. There's some logic in what Commissioner O'Donnell says, but I don't think there's a lot of information in the staff report regarding that. Could we have more information regarding the proposed community benefit and how to evaluate it? And I guess that's where I would end it, but I think there's real value to be had in this case with not pushing this on to Town Council with a recommendation for or against, but actually trying to come up with a project that fits in this property.
Is that in the nature of a motion?
Yeah, that was a motion. I don't know if we continue to date certain, but my motion is to bring this back before the Planning Commission with at least those specific items that I've listed addressed.
All right, is there a second?
I would second that.
All right, so discussion. Commissioner Sayak.
I would support the motion. I just do want to clarify that my concern is having both the 35-foot max and a cellar element. If a future design were to bring that down to 2 stories, I can certainly accept the grading associated with the cellar element to bring down the height. So just wanted to clarify that.
Commissioner Bourgeois?
I'd like to clarify a couple things. I'm going to go ahead and support the motion because I'm hearing kind of the same concern from a lot of commissioners. I wasn't necessarily requesting an additional analysis. In my opinion, the project's okay with relation to the riparian corridor. I was more just making those comments, and this is an early project that is applying these guidelines. I want to make sure we get the process right. And I would like to make a couple comments. I'm hearing everyone's concern about the mass and scale. And I share them, but I think of all the sites, this is a good site to put a big building. So it'll be interesting to see what they come back with. I would like to comment on a couple things that haven't been commented on yet, and that is community benefit and tree removals. Personally, I think it's an interesting community benefit, and I would be supportive of it. I remember the Director of Public Works giving a talk to the Sustainability Committee about what a difference the LED lights made on the Christmas tree. It went from 200 lights that cost us $2,000 to run, then we went to 2,000 lights that cost us $200 to run. So there's a significant cost savings in electricity for these LED lights. So I think that's an interesting community benefit, and I'd support that. I'd also support the additional tree removals, removal of trees 1 and 2, which were in question. I would not go out of your way to save those trees. That's just my opinion. You can take out all the eucalyptus trees you want. And I thought the landscaping plan was very good. So those are some additional thoughts.
Other comments? Let me make a couple of comments. I certainly agree. I would hate that, and I'm not sure the motion intended this, but since Commissioner Bourgeois really isn't asking for this study and this project, I would hate to send these people back with the supposition that they got to do it because some commissioner who didn't want it said it. But if some other commissioner liked the idea and doesn't have an independent reason why they ought to do it, you can certainly, that seems to be included in the motion, and you can clarify that for me, please. As far as the cellar is concerned, I'm aware of the city's policy when it comes to residences. I'm not aware of any similar policy when it comes to buildings of this nature. Maybe I'm forgetting something. But the idea with residences, there's no particular reason why that carries over to a building like this. The real question is it too big? If there's 1 story underground, I don't really care about that. My question is what's above ground. I do think the idea of how much excavation you take to get that is important, but if you say in the same breath, but if it were only 2 stories dig away, then it kind of takes away from the excavation issue, I think. As far as the colors are concerned, I'm not sure we're at the stage, and I'll ask this question, where we're talking about colors. So is there architectural site approval subsequent to this, or what?
Yes, architecture and site approval would be required if the PD is ultimately approved, and at that time, staff would obviously take into consideration the comments that the commission and/or council provided during the plan development process during that.
So I'm just concerned that we be precise in what it is we're asking these people to do, because it is not a snipe hunt that we're sending them on. And at the moment, it's fairly vague to me what they're supposed to run off and do in this time. So those are my comments. Anyone have any other comments? Commissioner Machici.
Yeah, I'm going to support the question. I'm not sure what they're being directed to do now, from what I've heard. So I would like that repeated in the motion.
That was a motion that I made originally, and so I was listing all those things which I believe to be concerns expressed by the commissioners. I appreciate that Commissioner Bush. I am not intending to give to the applicant 1, 2, 3, 4, 5, do this, come back. If you've done it, then your project is recommended to Town Council. What I heard were concerns that the Commission would like more information on. And I heard a concern from Commissioner Bourgeois that he wanted to get the process of the riparian corridor right. I don't want the applicant to run off and do a costly study of riparian habitat. I want to make sure from our staff that they believe the process has been done right here. One sentence in a future staff report would be sufficient, as far as I'm concerned, to take care of that. I understood Commissioner Sayak to have a problem with or request further information on grading. I understood other people to say that they were concerned with the size of the building. The purpose of the motion and the direction of the motion is we have tiny projects that we continue time and again for people to do tiny things. And if we have a large project that's coming in as a PD, I think it's our responsibility to spend as much time and consideration on that and tell the applicant what our concerns are and then consider that in due course rather than giving a yea or nay decision right out of the box. So my motion is designed to give us more information to address the concerns that have been raised tonight.
Other comments? I'll call the question. All those in favor?
Aye.
All those opposed? Nay?
I'm sorry, nay.
Okay, so it's, how much, all right. 2 opposing and the balance in favor.
You need a date certain.
What is a reasonable date?
Staff would recommend August 26th.
And I guess the question, well, I'm going to look to the applicant, and if the applicant feels that's too short a time, I would invite the applicant to tell us that. I will reopen the hearing if someone walks up there, it looks like they want to tell me something. All right, I will reopen the hearing on that narrow issue.
Yeah, I think that's more than enough time. In fact, we'd be prepared probably for the July 22nd meeting if that was acceptable.
I don't believe we have a July 22nd meeting, if I recall.
But if they're comfortable accommodating the commission's requests by the August 12th meeting, that's comfortable with staff. And if for some reason we're not able to get that information, then we'll continue the item.
Okay, we happen to take one meeting off a year, and that 22nd is that one. Okay, thank you very much. I'll close the public hearing again. And so now we have a date certain. I don't think we have to do anything with the motion, do we?
No, my understanding is that the motion was to continue the matter to that date certain, which is August, what was that again? August 12th. Anyone following this application, there will be no further notice of the hearing that has been continued to August 12th.
Okay, moving to the fourth and final item, 14680 Keto Road, and I would ask for the staff report.
Assistant Planner Marnie will be presenting the report.
If it's green light, you're on.
The subject property is located at 14680 Keto Road, located just behind 14670 Keto Road and approximately 300 feet north of Montclair Road. All surrounding properties are single-family residential. The subject site consists of 40,946 square feet and looks similar to a flag lot, but the site does contain the required 80-foot frontage on Quito Road, and the lot is fully conforming to the requirements of the R10 zone. The applicant is proposing to replace the existing house and the 3 remaining untouched accessory structures on the site. The design for this site began in early 2008 while the property owner remodeled the guest cottage. When the applicant discovered later that year that his original desire to merely remodel and add on to the existing home was not an option due to the type of construction and the town's demolition policy for pre-1941 homes, staff encouraged the property owner to come up with a complete design for this site and all the accessory structures. The application was officially submitted to the town in February of 2009. It was discussed at a pre-application meeting that due to the approval of the residential design guidelines, this property was now subject to a maximum floor area as specified in the Hillside Design Guidelines and Standards, and would require Planning Commission to approve the application. This application is the first to be subject to these new floor area regulations. The subject site along the property the subject site, along with the property to its north at 14610 Quito Road, are both larger estate-style properties with multiple accessory structures in addition to the larger main house, and are primarily surrounded by smaller subdivision lots with an average home size of about 2,500 square feet, as shown on the chart within your staff report. The property also sits along the town boundary adjacent to the city of Saratoga, which includes larger homes and properties. The proposed application does not create the largest house or the largest floor area ratio. The applicant is proposing 5,987 square feet of living floor area, inclusive of all accessory structures, and a detached garage with 1,242 square feet. The property directly to the north at 14610 Quito Road is the largest house, according to county records, at 7,312 square feet of living space and 3,117 square feet of garage space. The applicant is proposing to rebuild the main house on the existing foundation with the addition surrounding the interior courtyard. The applicant is proposing to remove and rebuild the detached garage, shed, and greenhouse in new appropriate locations on the lot. The applicant is proposing to retain the Spanish hacienda architectural style in the rebuild, and the proposed design was reviewed by the consulting architect, who found the design to be well done with high-quality materials and details. His report is included in the staff report for your review. The application was also reviewed by the town's consulting arborist. He found that all the trees being removed or significantly impacted would conform to the town code for removal and replacement. His report is included in the staff report as well. The application does involve the demolition of a pre-1941 home and was reviewed by the Historic Preservation Committee at its March 18, 2009 meeting. During the rebuilding of the cabana in 2008, a concerned neighbor brought it to staff's attention that she believed this property and its structures to have been part of the old adobe estate located next door to the north of this property. Prior to HPC's meeting, staff reviewed all town and library records in regards to the old adobe estate to determine if this was a possibility. While staff was unable to confirm or conclusively deny this concern, it was with that concern in mind that the HPC recommended approval of the demolition. The committee's comments and findings are included in your staff report. In conclusion, as stated in the structural condition report, the existing house is a safety hazard and should be removed. The proposed application is well designed with a single story that promotes privacy for both the applicant and their neighbors. The square footage and the floor area ratio are similar to those of the immediate neighborhood, while the relocation of the accessory structures provides a more functional flow of the property. All trees being removed as a result of the project conform to the town code for removal and replacement, and as a result, staff recommends the Planning Commission approve the architecture and site application subject to the attached conditions. Staff is here if you have any additional questions.
Are there questions of staff? There appear to be none. I would invite the applicant to come forward. Okay, before you speak, we discovered a staff question.
I apologize.
Mr. Bridgewater.
No problem.
If I could have one quick staff question. I don't remember seeing a landscaping plan. Maybe I missed it, but are the tree replacements going to be on site, or are they paying an in lieu fee?
No, I believe that the applicant is going to provide those tree replacements on site. That is usually something that is required on the plans prior to, he has to apply for tree removal permits for those through the Parks and Public Works Department, and at that time, the Public Works Department will determine how much canopy replacement is required for those
But the
trees.
intention will be, first and foremost, to replace them on site?
I believe so.
Okay, thank you.
Please identify yourself.
Dennis Hayes, 15048 Brewster Avenue, San Jose. And thanks for staying up so late. Probably don't do that all the time, so appreciate your consideration for this. When the Wagners purchased this property, it was just a collection of buildings that were falling apart, basically. And they saw basically an opportunity to really create something special. And so we sought out to do the design work for these different buildings and bring it back to life is basically what we were trying to do. And when we started the design, it was designed under the R110 standards, and this particular lot was over 30,000 square feet, which did not have any floor area ratio maximums. And that's not to say that we wanted to get the biggest home possible on this lot. The actual intent of this was to try to stay in tune with the Mission Hacienda style architecture, and at the same time create a true courtyard. Right now, when you drive up to this property, there is kind of a courtyard, but it's really doesn't have a definition, and along with that, there's no clear entry feature on this property. So what our goal was to try to create a clear entry feature, create that, and in doing so, create a true courtyard. This courtyard, as staff said, creates privacy not only for the occupant of this residence, but for the surrounding neighbors. This is kind of one of those unique situations where the lot is completely surrounded by residences. So in that sense, the courtyard is also appropriate. In doing that courtyard, we needed to add that square footage, and with that square footage was living room, entry feature, and formal dining room on the north side, and master bedroom extension on the south side. Also, we realized that the garage, there was currently a 3-car garage, and it was just stuck in the middle of the backyard of the property, and we realized you're going to have cars going all around this property just to get to this garage. So we took the garage, moved it into the driveway, so as you come up the driveway, you drive directly into that garage, and that helps alleviate some of the noise abatement, potential dust, that sort of thing. The other notable things about this property is that we also wanted to keep in a 1-story design, so it wasn't visible from the street. It currently is really not visible from the street anyway, just by the configuration of the lot. But we wanted to keep that 1-story design so it would have minimal impact as far as the surrounding neighbors were concerned, too. We didn't want a big 2-story property with windows peering into the yards. So we really tried hard to keep it as a 1-story design. Also, we feel it's fairly compatible with the estate property that's to the north of it, although it's much smaller. The estate property to the north of it is 7,312 square feet of living area and has 3,117 square feet of garage. That makes for 10,429 square feet. Ours is considerably smaller, as noted in the staff report. Also, there are some properties across Quito Road in Saratoga that are larger lots that are in transition as far as tearing some of those homes or adding to some of those homes. So that's something to keep in consideration. The other thing we wanted to do was to have somewhat of a green design element in this, in the sense of reusing some of the structural elements. There are some big old posts that are supporting the verandas that currently exist that we want to reuse for the verandas that are going to be rebuilt on this property. And we're also going to be doing some rainwater abatement. We're going to be doing solar panels in the future, and that's another reason for the flat roofs with the parapet walls, is to incorporate the solar panels down into that so the neighbors don't see those solar panels. And then there's a series of other green measures that we're taking. We basically filled out the Build It Green checklist, and there's a series, and I think you might have that with the staff report. One of the other things I wanted to note, too, is that in order to grant approval for this project to exceed the maximum floor area, we had to meet a series of conditions, and all those conditions have been met. One of the conditions that I needed to speak on, though, was the Title 24 requirements. And in speaking with the Title 24 consultant, he said that he would make it far exceed the 10% minimum over the minimum requirements. Basically, what our whole idea about this project was to do the good neighbor sort of practice, not make an overly high, overly built structure that looms over people's yards. And I thank you for your time.
Thank you. Let's see if there are any questions. Are there questions of the speaker? Thank you very much. You'll have an opportunity to rebut. The first card I have is Carrie Pope.
Good evening. My name is Kerry Pope, property owner at 120 Montclair Road, which is the property immediately adjacent to the southern boundary of 14680 Quito Road. And I've had a chance to review the plans in the main. I believe the Wagners have done a terrific job on the main house, but I do have a concern about the setbacks and the placement and the number of the ancillary buildings and the impact that it's going to have on us. We bought our property in December of 1999 and spent $500,000 to remodel it, so we have a vested interest in maintaining the environment as well.
Let's make sure that this doesn't take off your time while
Thank you very much.
Adjusting this.
Wait
1 second. We're going to give you this moment
Okay,
so
thanks.
you can set this up.
Okay.
Somehow that's not right.
So this is, if you'll bear with me.
All right, now we can start.
Okay. Can you see that all right?
Yes.
All right, this is the view of the property line from our breakfast room, if you will. And this is the auxiliary building that was built beginning in December of 2007, I believe. And you can see the story poles here. And the concern that we have is that, and it is dark, and I apologize for that, but this is the property line continuing. The concern that we have is that the plan allows for placement of additional ancillary buildings, auxiliary buildings in this area up to 15 feet and within 3 feet of the property line. And that begins to look much like, this is, the building is well done. I don't have any issues other than the fact that you cannot say this doesn't have a visual impact. And imagine if you would, a similar building, placed 12 to 15 feet high and very close to the property line. So the concern we have is the amount of space, the number of buildings, and we believe that the Wagners can get what they want with the main design. But specifically, on page 4 of the report, there's a reference to a 260-square-foot storage shed becoming a 288-square-foot art studio. I'm not sure which property that is or which building that is, to be honest with you, but the thing that concerns me is primarily the same area of the property along the southern property line, which is this fence line. And it says that all accessory buildings are be less than 15 feet in height, which is pretty tall, and within 3 feet of the fence. So when we moved to the property, we moved into the area before it's park-like setting. We have 3 small children, a 7-year-old, 2 5-year-old boys, and we think that this could have a substantial impact on the nature of the neighborhood and certainly of our property. So that's my comments. Thank you for your time.
Thank you. We have Commissioner Bourgeois would like to ask you a question.
Yes, sir.
Thank you, Mr. Pope. Would you mind putting that back up for a second? And scooting it over to the area you're concerned about, the other way. There you go. Thank you. So the plans show, and I visited the site, and I'm trying to remember that back area. The plans show an existing garage back there and another existing shed.
Well, the garage is substantially removed from the property line, I believe.
And the shed, it shows the shed's...
The shed is substantially more than 3 feet, and it's also much lower than 15 feet.
Okay, but you can't see that currently from your...
Correct.
From your... Okay, thank you.
And then the last point, we don't know which trees are going to be removed. Our fear is if the 5 trees that are going to be removed to right here. And the applicant can address that.
Thank you.
Thank you.
Any other questions? Thank you very much. Next speaker card I have is for Dennis McCarney.
Dennis McCarney, 116 Montclair Road. I live next to Carrie on this side over here. So this is what he sees from his backyard. I see that plus the other side from my backyard. So quite a bit of mass. Generally, I have no problem with the project, but I have 2 issues. One is the setbacks. It's kind of hard to tell where that's about 3 inches from his fence. And so having all that mass back there is somewhat of a concern. And the other concern I have is removal of trees. This is Keto Road, and that area, there's lots of trees in there. It provides a sound barrier from Keto Road, and there's been a lot of trees taken down on this property already. So I would prefer that the trees that are going to be removed be replaced with something that's equal. And those are the only 2 objections that I have to the whole project, actually.
Okay, are there questions? Thank you very much. The next card I have is Harry Laughlin.
Hi, our property is...
Excuse me, just for the record, if you don't mind, could you just repeat your name and your address?
Sure. My name is Harry Laughlin, and my address is 175 Old Adobe Road, and we're probably directly north of the property of Mr. Wagner's. The main problem we have with the project is the 56-foot-long garage that is going to be 3 feet from our back fence and 12 feet high. And currently, there is a whole bank of trees that we look at now, and over the trees, we can see the Santa Cruz Mountains. And I put a stick up that was 12 feet high, and of course, the trees will be gone because the garage will be where the trees are. And we will no longer be able to see the ridge of the Santa Cruz Mountains. So it'll impact the view of our backyard significantly.
That's your full statement then?
Yes, it is.
Are there questions? Thank you very much. Next and final card is Citizen Ray.
Well, end of the evening. Guess what? I have the same complaint that I started with. Recommendation by the staff. How can they possibly make a recommendation for or against without ever hearing the public's position? They only activate from private conversations, maybe you call them a secret, with the applicant. Are you listening, Ms. Rooney? No, she's not listening. Ms. Rooney, you try. You know, the red, white, and blue up there, we hope the American democracy comes first. But sometimes it starts to fail, like it's failing now. I drove out to the property today. Talk about it. I didn't realize, and I met these folks, I didn't realize they were new owners. Talk about a tortured, convoluted approach to a huge home that's there now. Couldn't believe it, you know. You barely got my car through the driveway without hitting something. My gut feeling if there was ever a justification for a planned unit development approach to development, this is the property. Why there's no PD, I'll never understand. Okay? This should be done under a PD to try and get, after you send it back to the, continue it, and give them a chance to do some magic and bring it back to you, then you have a chance to evaluate what's going on. And what you need to have is three-dimension architectural renderings. Two-dimension, like up here now, you can't tell anything with that tortured, convoluted piece of property that was built. The building was built in 1920. 1920. The neighbors are here, and they're presenting their problems, their issues. Send it back, continue it, let them come back as a PD, and then take it from there. And tell them it's too damn big for a spec house. Too big. Exceeds the FAR. It should be, as new development is required to be, it should be up to standard. The standards of Los Gatos, not Gilroy.
Thank you.
Thank you.
The applicant?
I just want to thank the neighbors for coming and voicing your concerns, and that is one of the things that we definitely want to work with you on that. And just to let you know that the art studio that's going in is, yes, it is a little closer, but the maximum height on that art studio is 15 feet, but we're going to 12 feet as one of the criteria to kind of remedy some of the impact on the neighbors. The other thing about that is that we are, when I look at this, it doesn't look like we're even removing any trees in that area. Those trees are to remain. My eyes are so bad I can't see this small copy here, but it looks like there's an oak tree and possibly a fruit tree that are going to remain to help with a buffer for that art studio. Now, as far as the garage goes, the owner is willing to work with the neighbor behind in terms of moving that a little bit further away from the property line. However, there is one concern in doing so. There is a tree that is to the west of the garage where we have it shown on the plan that could be in conflict if we move it too far that direction. Also, we need to take in consideration the turnaround radius for the fire department if we move that further in. But I think we do have a little leeway to do that, and also the neighbor has voiced, or the owner has voiced that we would be more than willing to plant a whole series of trees along the back wall of that garage to help remedy the visibility to the garage and kind of give it a green type of a barrier right there. I think that was all the concerns that were voiced.
Are there questions? Commissioner Bourgeois?
Thank you. Do you know the height of the shed where the art studio is going, approximately?
I'm thinking, I'd like to say 10, 11 feet or so, somewhere around there. It's not, from what I understand, it's almost a flat top type of, it's a gable or shed roof? Okay, it's a convoluted structure.
Okay,
but
so you're going up maybe 2 feet max
most,
at that location.
Yeah. And I'll add, too, that the art studio is not like the cabana that they were showing in the photographs. It has a tile gable roof on that. So it's only the peak of the roof that is actually at the 12-foot line.
And there's no flexibility to move that, to increase the setback there?
I'd have to confer with the owner on that one, whether they're willing to do that.
Okay, thank you.
Commissioner Telesfor?
Follow-up to that, when I was out there today, there's the art studio, and then was there another building beside the art studio? proposed art studio?
Not being proposed, other than the
No,
existing-
was it there now, existing?
There is a shed.
A shed.
Currently right there in that, basically in that location. The shed is kind of askew. We're
Yes.
moving the art studio.
Is
off.
that's staying or going?
The shed is going away.
Okay, so that, okay.
The art studio is being built to replace the shed. It's built in place of the shed. It's almost on that same footprint.
Okay, that clears it up. Thank you.
Other questions? I have a question. Did you meet with the neighbors prior to coming here?
I believe the homeowner has had conversations with various neighbors.
And were those conversations transmitted to you?
Yes.
Okay, because we heard somewhat different comments from each person, and they all seemed kind of doable comments, but they weren't done, as near as I can tell. So it makes it difficult. If I were to sit here and simply go through the comments I heard from each of the applicants, we could sit here and do that, I suppose. But what I'm troubled by is to do that, and maybe the commission thinks we could, but for example, one concern was that you not do something that maybe you might do, which led me to believe that if you're not going to do that, we could just stipulate and put it in there that you're not going to build there. The other was this question of setbacks on certain of the buildings, and to say, well, we'll work with the neighbors suggests to me that that's fine, come on back to us and tell us when you've worked with the neighbors. I would like to see you work with the neighbors so that when you did come back to us, you could say, here's how we've solved these problems, or we were unable to solve a problem because. Now, if we were able to do something like that tonight, I can understand some sense of, not delaying it, but the easiest thing to do from my view would be to allow you to sit with your neighbors, and they have to be reasonable, you have to be reasonable, and then come back in short order and say, this is what we've done, because we're not set up to do design work. And you would be happy to know that we shouldn't do design work, so.
I'd like to clarify on that in the sense that the way that I understand is that the neighbors, do they look at the plans and then they voice concerns after?
Let me stop you for a second. You're looking across the room, and I understand that, talking to your client, but since the record really can't pick that up, I wouldn't mind if you want to have your client come up, and to the extent you don't know something, one will identify him and he can answer it for you. If he's worried about speaking, that all he has to do is give us some facts if you don't have them. So if you wouldn't mind, sir, if you would come up and identify yourself, and you are the property owner, I take it. You both stay up there, because I think he wants you to do the talking.
I'm Lyle Wagner. I'm the property owner.
All right. Now, you were looking to him for some answers. Could we find out what you need answered?
The question
regarding the setback on the garage and this art studio.
Okay, with the setback on the garage, I did have a meeting with the
neighbors
yesterday, and we discussed that I would move the garage back. We'd have a 5-foot setback, and we would plant trees that we would both agree to, that wouldn't harm the foundation. And
do you have any problem?
I thought everything was okay.
Do you have any, we need to have something brought before us telling us how you're going to respond to your neighbors' concerns, assuming we have somewhat the same concerns. Do you have any problem with us continuing this matter so you could do so? Whether you do or not have a problem, it may not decide this matter, but I just want to know if you do.
Well, I think we could probably come up with something right here.
I don't think we're going to do that. I need either you to tell us exactly what you're going to do right now, or I think, think about it.
With regards with the garage, we're going to have a 5-foot setback from, which direction is that? From the east wall? Mm-hmm. From the east wall. And we're going to plant trees that we agree on. I'm very flexible with what.
How about the height of the buildings that we've heard about? One neighbor was concerned that he would lose his view of the hillsides.
Yeah. I don't know what I can do.
All right, I'm not trying to talk too much here, so let me invite some of my fellow commissioners. Do you have any questions of these people? Yes, Commissioner Telesfor.
What is the height of the garage? Can you clarify that? 12?
It's 12 feet.
12 feet now? Okay. We'll just stay with the garage, and then we'll move to something else, but I'll wait. Somebody else. I just wanted that clarified with me.
Thank you. I think unless there are questions of these gentlemen, I'm going to thank them. Go ahead.
Well, then I have another follow-up question about your art studio. I'm looking at the plan, and I was wondering, you're moving it forward, which would seem to be moving it into your neighbor's viewscape, where presently he doesn't see, what he's going to say is blocking his view. So I'm curious, is there a way that you could just rebuild the art studio where your present shed is?
Right now, the shed is real close to the oak tree.
Okay.
And we want to move it further away from that oak tree, and it also sits askew from the property line. We want to move it parallel to the property line, just so it fits right in there. And also, we have, let's see here.
Arbor structure.
Yeah, there's an arbor structure that is underneath the oak tree.
Okay. Well, that answered my question. Thank you.
Commissioner Bourgeois?
And again, you have a 3-foot setback, and you've compromised on the garage. Would you be willing to go to a 5-foot setback on the art studio as well, or? And again, if you don't know right now, that's fine to say you don't know right now. But
Yeah, I could do that.
All right. Any other questions? Thank you very much. I'm going to close the public hearing and ask the commission for comments, motions, whatever you'd like. Yes, Commissioner Jensen.
I'd like to make a motion to continue this project to a date certain. We can ask the applicant when he can come back in order for the applicant to work on a redesign with the neighbors. I think what we're doing now is very inefficient.
Is there a second?
That.
Commissioner Telesfor. Is there discussion? I'm going to call the motion then, unless there's discussion. All those in favor of the motion?
Aye.
Anyone opposed?
Nay.
One opposition and the balance in favor. Now we need a date certain. Okay. Could we ask the applicant to come forward so I can, I'll reopen the hearing just for the question of, would July 8th be enough time for you?
More than enough time.
Okay, then I'll close the public hearing. So the date certain, and I'll look to the maker of the motion, if this is acceptable, would be July 8th. Okay, so that's it.
Thank you.
Okay, what else do we have on the agenda? Do we have any? Okay.
If we can go through exactly what the application is.
I just want clarification for the applicant as far as if those are the only concerns that Planning Commission has as they're looking at these changes, if there are other changes that the Planning Commission or other aspects of the Planning Commission is concerned about.
Let me try to state some of the ones that I remember, and then people can correct me or add on to it. But Mr. Pope had said the plan allows for an additional building, which he was worried about. It's not shown, and I don't even know if it's going to be there. He showed it on the photograph he had. It was to the right of the photograph. There's nothing there, and he said the plans would allow for a building there.
That's the art studio that we were discussing.
Okay. Well, he's concerned about that. It's to be 15 feet in height, and it's to be within 3 feet of the fence. He's concerned about both of those things. And he's also concerned that to do that would require the removal of trees, which he's not in favor of. So that's one. I'm just going to repeat to you what the concerns are. Dennis McCarney said that he was concerned about setback and tree removal. Mr. Harry Laughlin said that the long garage would require tree removal, that it was 12 feet high and within 3 feet of the fence and would interfere with his view of the mountains. That's what Mr. Laughlin said. And those are the ones I have. Does anybody who isn't down there chatting have anything to add to that? I'm asking questions in a minute, so. Yes, Commissioner Bourgeois?
I understood staff's question to be if the commission had any concerns beyond what we heard, the concerns of the residents.
Well, I wanted to make sure that the commission agrees that we want to look at those.
At those, yes. And this commissioner has no concerns beyond those that the neighbors expressed.
Does anyone have additional concerns? There are none. Okay. All right, so I think that's it on that agenda item. Thank you very much. Now,
Yeah.
I guess I want to know whether the Director of Community Development has anything?
I just have one item for you. For those of you who may not have watched the last council meeting, the project that you heard probably your last, no, it's been a couple of meetings ago, 20105 Foster Road, was remanded back to the Planning Commission. The council gave some very specific direction, which I think was very valuable direction because it really clarified how the council reviews the hillside guidelines. The council approved the home to exceed the 18-foot height limitation, so it can be a two-story home. However, they will need to redesign the west elevation to remove some square footage off the second floor, and that was really a privacy concern with the adjacent neighbor. They'll also have to submit the landscape plan, which would be required, and grading and drainage plan, which are required. That date hasn't been established yet, but that will be coming back to you to review those.
Thank you for letting us know. Are there commission matters? I think I've advised my fellow commissioners that I'm happy to say that I will be out of the country at the next meeting, so Commissioner Bourgeois will do a wonderful job.
I'll also be, and I've previously informed everyone that I will not be here on July 8th. I'll be in the country, but not in Los Gatos.
All right, so that's two of us. Will the rest of us be here? Good. Good. Any other commission comments? Thank you all very much. The meeting is adjourned.